as a judge, yes. I understand the thought and sentiment in a way. As a human being, I agree. However, as a judge, I have to follow the law. It's very restricted, at least in Wisconsin, about what records can be sealed.
They started early, so I'm starting early.
The authority is defined specifically by statute.
Christy.
Things like juvenile records.
The judge says
secrets, social security numbers, pre-sentence investigation reports, psychological studies, things like that are all defined in statute that a judge either is permitted to or is required to seal. Judges do not have broad authority to seal records that the judge thinks would be appropriate or to protect the interests of individuals, unfortunately. So because this is a trial exhibit, it's been received into evidence, because this is a public trial that does not involve a enumerated statutory basis for sealing, I don't have the authority to do so, even though I may prefer to do so. I simply just don't have the authority. So the request for sealing is denied on Exhibit 24.
Hello all.
I provided the attorneys with a printed version of all of the proposed verdict forms. Did anybody have any objections?
No. I don't.
Okay. So those will stand and be submitted to the jury. Is there anything else you want to address before we get back to the jury instructions? Okay, hearing none.
Actually, can we approach quick, Judge?
Yes.
The sidebar without the jury present. Well, good morning all. Sorry, he said 8:30, so I thought I had a good time. And thank you so much, Wendy, for the 30 corner kisses supporting my trip to Tennessee. You are way too kind. Thank you so much. Yes, they are very rough and they will put him in jail. Good morning, Fubar. Hey, Panella. Thought about this case and how humanity is so backwards. Yeah, I was just watching the commentary over there, and yeah, he's a military man. He should know better. No, he's not. Yeah, he. How tough is he? Hurting little kids. At defensive end at 235, he's not a little kid. I think it's per charge, right? Hello, Federowski. Yeah, Jamie is doing her vanishing trick today. She's the ninja. Miami Spice. Welcome back from the beach. Hope the beach was nice. Today started out raining and now the sun is out. Of course, when I have to sit here, the sun is shining. KDP and Michelle G. Hoping the jury comes back within 3 hours and not guilty on all counts. I'm not too sure it'll be that fast. I know that the Chad Daybell thing is starting today. Shizzy was talking about he might cover that. So when we go to Verdict Watch, I might ship you over there so you can follow that case if anyone wants to. So, yeah.
1017, those same objections would apply to 1072 because the same issues exist in both instructions. So I've noted all of them for purposes of preserving the record. Are there other matters that you want to address in 1072?
Yes, Judge. In 17 as well as in 1072 regarding the matter of second-degree reckless homicide on page 10 when you're talking about the homicide, and on page 20 when you're talking about the recklessly endangering safety, both in the second-degree matter. Both of them merely say the difference between first and second is the additional element. There is no mention in that discussion of second-degree reckless homicide, nor mention in the second-degree reckless endangering safety that it is the state's burden to prove beyond a reasonable doubt. I appreciate that it is in first-degree reckless homicide and it is in first-degree recklessly endangering safety. However, I think not including it in second to make sure and clear that the burden is on the state is in direct contradiction to the State v. Austin 349 Wisconsin Second 744 case that we've been discussing. This mistake, error in the instructions that were included is, I think, exactly what Austin says on paragraph 7, mentioning the jury instructions in Austin. Said, however, there was no mention of the burden of proof relative to self-defense. And it talks about that in the context of recklessly endangering safety. And later on page 17, it talks about
Hey, this way up.
the standard instruction implies that the defendant must satisfy the jury that he is acting in self-defense. In doing so, the instruction removes the burden of proof from the state to show that the defendant was engaging in criminally reckless conduct. So I'd ask that on page 10 and on page 20 when discussing the second-degree reckless homicide and the second-degree recklessly endangering, that Your Honor add the words that I believe were added in other aspects, and that Mr. Mew was not acting lawfully in self-defense.
All right, the objections noted. I am declining the request for the modification. Again, this comes from the pattern standard language from the jury instruction book, authored by the jury instruction committee, a committee of multiple judges who have studied these issues and have vetted appropriate language. The self-defense language appears in connection with first-degree reckless homicide and first-degree recklessly endangering safety. The jury will be instructed that one is not engaging in criminal reckless conduct if they're acting in self-defense. When we get to the second-degree versions of those offenses, the instruction makes explicit reference back to the wording from the first-degree offense, but simply tells the jury that the absence of utter disregard for human life, but the instruction for the second-degree offenses instructs the jury that they do not have to find the utter disregard for human life. So it's incorporating by reference the first-degree language. I think it is adequate. I think it is accurate. The attorneys will have ample opportunity to argue their respective points,
Hey, Christine.
including the importance of the self-defense being disproved by the state beyond a reasonable doubt.
Well, if you saw my
What's
recap video, I think he will be
the
convicted in the
only additional request after reviewing the instructions, Judge.
Okay, and then last night we went through all of the other instructions. I'll give again another open call to
stupid work.
additional instructions that you think, additional removal of instructions. Is there any changes, objections, concerns?
Luis Rojas, if you want my stock portfolio, just stay away from all of them, because I invested in our national plane, whatever, travel thingy, and they have crashed 98.7%. And they're probably going bankrupt, but Now I'm just sticking onto them because it will cost me more to get rid of them. Yes, they're still doing the jury instructions because the jury isn't supposed to be there till 8:30, 9:30 Eastern. Yeah, because they put in all those lesser includers yesterday, he will get convicted. It's always. Hey, Pixie, are you number 69? You could be. Oh, I haven't fixed my Elgato yet. But giggity. Good morning, Nanny Doo. Diversification. Well, I do have a lot of diverse stocks, but all of them is bad. So follow Nancy Pelosi, don't follow me.
That you have to the jury instructions as presented.
Judge, regarding the excuse portion, I agree you can take that out. I'm not going to argue that in any way of provocation. So it was one of the bracketed instructions. It's on page 3.
Yes.
It's a single sentence paragraph.
It is removed. Anything else from the state?
Not on jury instructions.
Mr. Nelson?
No, Judge.
Okay. So I'll have the instructions finalized. My intent is to read before you argue. I'll also have the instructions displayed on the monitors so the jury can follow along. The jury will be provided with a few copies of the printed instructions in the deliberation room for their reference. Mr. Anderson, at sidebar, you said you had a motion to make?
Yes, Judge, I have a motion to strike one of the jurors. It was brought to my attention yesterday that during portions of testimony yesterday, one of the jurors was sleeping for an extended period of time and to the point of nodding off and then jerking awake. Both sides have a right to a fair trial, which includes juries that are attentive. I'm looking at Wisconsin Supreme Court case, State v. Novi, 346, Wisconsin 2nd, 289. If there's a conviction, the defense could also try to argue that it violated defendant's right to fair trial. So obviously we want jurors who are paying attention to the evidence. So it's a two-step inquiry. One, it's a fact determination whether the juror was actually inattentive to the point of potentially undermining the fairness of the trial. And 2, whether there's this is the appellate review standard, if there's prejudice as a result.
Which juror?
4021.
Judge, we don't agree. I'm not looking at them, so I don't agree with factual basis.
Mr. Anderson, if you want to pursue the matter further, you'll have to provide a witness.
State calls Investigator Schultz.
Investigator, please stand, raise your right hand and be sworn.
You can trust him.
To start the testimony you're about to give in this matter, shall be the truth, the whole truth, and nothing but the truth, so help you God.
Please have a seat in the witness chair. Mr. Anderson?
You've already testified, but can you please state your first and last name?
John Schultz.
And were you present throughout testimony yesterday?
Yes, sir.
At portions of the trial, were you watching the jury?
I was.
Was there a specific point during trial period of time, I should say, where you noticed a concern about whether a juror was paying attention?
Yes.
What did you notice?
I observed one of the jurors with her head down and would startle up with her head on numerous occasions. What kind of time period, if you can recall? Was it like 10-minute time period, half hour, longer? About an hour.
They want a jury thrown out because the jury might have fallen asleep. But have you watched this case? I fell asleep a few times too. I turn off my screen and then I just start walking around in my room to get the blood circulating. So yeah, why didn't they bring it up at time? Because this little weasel had to tell them so they could try and throw that guy out.
And she was dozing off and appearing to start awake.
Yes.
Multiple times.
Yes.
And from reviewing the our jury list in our office. We believe that to be juror 4021.
Correct.
Nothing else, Judge.
Mr. Nelson?
What time did this occur?
I can tell you during what portion of the trial, sir, but I don't recall the time. I apologize.
Just yesterday this happened and you don't know what time it was when it happened?
Correct. I can tell you the portion of the trial.
Let's start from there. During which witness?
Lieutenant Hart.
And during Lieutenant Hart's direct exam or cross exam?
It would have been during her direct exam.
You don't know.
And that was the before the video or after the video?
During the video.
So was it during the exam or during the playing of the video?
I apologize. I think I'm getting confused. It was during the playing of the video.
Was it at any time other than during the playing of the video?
Not that I observed.
When you made these observations, you were sitting next to attorneys representing the state?
Yes.
Did you make note to them, pass a note, give an elbow, whisper in an ear?
No, I told them after or during a break.
So you made this observation while it was happening and you just, for lack of a better term, sat there and let it happen?
Yes,
Didn't bring it to the attorney's attention?
I did during the break.
When you say the break after the playing of the video,
I believe so, yes.
was there a discussion about whether the state thought the juror was on the state side or the defense side?
No, sir.
What was that discussion? Who did you tell?
During the break, I just told the attorneys that I observed a juror who I believed was sleeping. But I noted that I believe she was sleeping and not just closing her eyes because of her head quickly coming up like you would when you startle from waking.
And did you, at the time you didn't, your estimate of the time is fair to say rough.
Yes, sir.
You, during the actual live testimony from Brandy Hart, you didn't make an observation of any of this, correct?
Yes, sir.
It was
Correct.
It was only during the playing of the video.
Correct.
It was only during a portion of the playing of the video.
Correct.
And your observation was just as you said, she had her chin tilted forward towards her chest at a couple of times during the playing of the video.
Yes, sir. Her chin tilted, eyes closed, and then head would come up quickly.
And when her chin was down and her eyes would close, would that last for a moment or would that last for 10 minutes or you don't know?
It's allowed. It's the same with people who are witnesses can be who are victims can be in there.
I was out watching her over 10 minutes, so I would say a moment.
Okay. So
Thank you,
her
Dave.
chin would go down for a brief moment and then she would bring her head right back up. That's what you observed.
Yes, sir.
You didn't look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed and then look over and see her chin down with her eyes closed. Agreed?
Sorry, I think I'm getting confused. Yes, that is what I would see.
I'm trying to figure out this, whether or not you observed her chin down, eyes closed, and she stayed in that position for some continued period of time, or whether you observed her chin go down, there was a startled moment, her chin would come up, or whether you saw something else.
I understand what you're saying now. So I was intermittently looking over, and during that period of time, there was times where I would just see her chin down, eyes closed. I would look back, and it would be that way, and then I would see her startle with her head up.
So you're not in a position to tell the court the length of time that you observed her to have her chin down with her eyes closed? Meaning,
Continuous? No, sir.
all right, you don't know whether that was for 5 seconds, 10 seconds, 10 minutes. You can't say.
Correct.
You just essentially noticed it a couple of times.
Correct.
And by a couple, 2 to 3, is that fair?
I'd say 4 to 5.
2 to 3, 4 to 5. Big difference.
And of those 4 to 5 times, half of them were you saw her with her chin down and she didn't make a response, and half of them were when she had her chin, you saw her make this, what you've called a startled reaction up.
Yes, sir.
That'd be a fair estimate.
That would be fair, yes.
And the times that you saw her with her chin down and eyes closed, it was again just a brief glance. You weren't dialed in, focusing on her. Agreed?
Yes,
You agree with that?
I do agree.
Nothing else?
So the 4 or 5 times, is that when you saw the head jerk?
It was Well, at times I'd look over and she just chin down, eyes closed, and then I would look over again and I would see that and then see the head jerk.
And did you see that for what period of time approximately from when you first noticed that till the end? Was it half-hour period of time, 45 minutes, hour?
Approximately over an hour.
When you looked over, if you recall, was it one of those two states, or were there several times where you looked over and she did appear to be alert?
Those were the only times that I'd looked over.
So when you looked over during that period, it was either chin down or startling.
He couldn't look past the lead prosecutor anyway.
Away.
Yes,
Nothing else.
You said it was only during the playing of the video. Agreed?
yes,
You understand that the video was less than an hour, correct?
approximately an hour. Yes, sir.
It's about 50 minutes.
Yes, sir.
Yeah.
So based upon that, you couldn't have been observing this for over an hour. Agreed?
I object that we played it for 56 minutes.
The record's,
56 minutes.
it wasn't over an hour. Agreed?
Yes, sir.
And you can't tell the judge during those 56 minutes when you made the first observation. Agreed?
Agreed.
A juror might have been sleeping while they played the video of the interrogation yesterday, so the state wants her kicked off.
You don't know if it was 15 minutes into the video, 30 minutes into the video. You can't say.
I cannot give an exact time. No, sir.
And all you do is, you said you saw it about this 4 or 5 times, correct?
Correct. Yes, sir.
And you're not in a position to say whether her
Hey,
head was
Jamie,
down for any
finally you can show up.
continuous period of time. Agreed?
Agree.
That's all, Judge.
Thank you, Detective.
Thanks, Judge.
Down. Is there anything else you want to say in support of your motion?
Judge, the video is obviously very important for the state's case. It was only played once. Clearly, we don't have enough time to play it again in closing, given the length of it. That would be our entire closing argument. Both sides are entitled to a fair trial
They have a time
with an attentive
time
jury.
limit on their
So
closing.
I think
Thank heaven.
I ask that the court strike juror 4021 as one of the alternates.
Mr. Nelson?
I don't think they've established a factual basis that she was sleeping. I think that there's reason to believe, but I don't think that they've established a factual basis of that.
I tend to agree. There are some clues to suggest that the juror may have been nodding off, but there's certainly nothing conclusive, certainly nothing that would allow me to make such a significant finding.
Oh,
I'll say, for my part, I was scanning the juror from time to time during the playing of the video as well. And my eyes were not fixed on them the entire time, obviously, because I'm trying to pay attention to the video, but I also was watching the jurors. I did not notice anything that would suggest somebody was sleeping. I have a different perspective than others. I'm not saying mine's better, it's just different. I did notice a number of occasions where people were looking down because they were writing on their notes, or they were averting their eyes, but they weren't sleeping. So I just say that to point out that there can be other alternative explanations for certain observations. The other point too is that even if we did have a sleeping juror, and even if that juror slept the entire presentation of the jail interview, it is a recorded interview. And if that juror ends up being one of the 12, that juror has the ability to request to watch the video. So it's not like live testimony that is lost forever. This juror, if they make it to the deliberation room, has the ability to view the video again and take that into consideration as part of her deliberations. So for those reasons, the request is denied. Is there anything else?
great trial, great
No.
chat. Smexy
Anything else from the
Thank you,
defense?
Daddy T.
Just like a break before we get into openings.
We will, yes. All right, let's take a short break. We will resume at 8:45.
Yeah, none of the officers was not telling the truth. Hey, Jamie, how are you this morning?
Hi.
Hey, Nick, how are you this morning?
Hi, guys.
State wants pro defense. Well, they don't know if it's a. They might do the Dr. G thing and read body languages, which is bullshit, and think they maybe it's the 90-year-old, and they think, well, because she's an old hack, she's been through more wars than Rambo, so she might be pro defense, but that was a stupid motion.
Well, from that little thing, they have a couple 70-year-olds on the jury too. So they picked them.
Yeah.
I mean, come on.
So yeah, you really can't fall asleep as a jury. No, but we don't know if there was no evidence that the person fell asleep. But it's really important that you stay awake because
Sorry. It just seems so stupid. And
JC isn't stupid. That's a good question, Jamie. You can't laugh at chat. I'm so sorry, JC.
No,
Jamie chose violence this morning. I'm so sorry.
Oh my God. Today has been a crazy day already.
I think you should say sorry to JC that you laughed at her.
Oh, well, I wasn't even I didn't even know what you were talking about. I was thinking about the old people on the jury. I'm sorry.
So, sometimes I would like to be in your head.
Well, I'm just like thinking, you picked these 70, 90-year-old people, and now you're mad. Why are you mad now?
Yeah, stop being bored. Maybe people wouldn't fall asleep. No, of course you didn't laugh at JC. It was just a joke.
I know. Yes.
But it's been a really boring trial. I have to stand up and walk around to get the blood running sometimes. We're talking about a lot of this, and they made it so boring. So it's his fault. No, I actually I did jury duty with a younger woman, probably maybe early 20s or something like that, and we had a lunch break, and we don't have a cafeteria at the courthouse, so I went out and bought me something, and she said, well, I brought a lunch, so I'm gonna stay here. That's fine. And I had a few errands to run, so I came back 40 minutes later. And she had pulled out 3 chairs next to each other and was sleeping in the deliberation room. And I came in, sat down, and sat drinking, and said, no, I'm not going to wake her up. She had her earplugs in. I thought, well, she needs to rest. And then the judge came in, and still nothing. And we were looking at each other, kind of laughing, and then the judge kind of wiggled her feet and said, are you ready? Oh my, what? I just laid down for a second. Yeah, you've probably been sleeping for an hour now. Oh, I'm so sorry. And we went in, took a break like 5 minutes later because she was just, brr. Her brain was all over the place. So yeah, it's really important that you listen to all of the good little tidbits, because both sides will try and slip something by you.
Mm-hmm. Oh boy.
Yeah, it was his motion, and he didn't even know what to ask. Stupid. Yes, they are closing today. Hopefully, Sharowski has a very good closing.
He's closing?
I don't know. I said hopefully.
Oh. Well, I said that yesterday. I hope it's him.
I fell asleep in the second of the new Star Wars movie, and I fell asleep at Batman Begins. That's the only 2 times I've fallen asleep in the movie theaters.
Really, in a movie theater?
Yeah, Batman Begins is a really boring movie.
I don't know if I remember that one.
Your first post-school boss had narcolepsy. We would always mess with him, especially when he would nod off in the car. My dad had narcolepsy, untreated. They didn't think he had it, And he was always sitting there at the table and falling asleep. And my mom was just, yeah, he's just so, that's because he's too fat. And then he drove off the road when they were going up to pick up my kids in a weekend. And then he went to the hospital or to the doctor the next Monday. And then he got one of those CPAPs and never had any problems with it again. But that was a scary one. He just, my mom said he was talking to her and then they drove right off the road. He just fell asleep.
God.
He had 2 days of jury duty and was struggling to stay awake. Day 2 at 25 years old. Some day I've told this story 1,000 times where I was sitting up there a couple of days before Christmas last year, and we just had to have 8 hours of cell bride. This picture was taken. You can see the the geolocation. This is the Google map showing that geolocation. On this picture is one battery for a chainsaw. This photo was taken at, here's the Google map. This picture shows one hubcap, and we had to sit for 8 hours. And I don't take notes for that because we have a long list of stuff. So you just sit there. Both the defendants were sleeping. That's their right.
Both the defendants.
Yeah, the one of them, he had done it the entire trial because it was long days. We were having, it was 8-hour days. I think we had 8 or 9 days in court with that case. So he just leaned back and just and the final day where we're just sitting there, it was just both of them were just snoring away. You still wake up sleeping. My dad loved after he got his. He never slept. He said it was better than being a baby. Oh, I'm sorry. You fell asleep at a NASCAR race. Charlotte is the most boring race on the all NASCAR races are boring because they're just going around in a circle. It's kind of like counting sheep because it's just.
Sue, you know that's Baker's favorite thing, driving in a circle.
What?
NASCAR, your favorite.
Maybe that will work, Beth. Constant motor sound can be like a lullaby. Yeah. Oh, the constant motor sound. Yeah. Yeah. You would hate to sleep in court and be sleep fat. Sit there drooling. Oh, there's nothing worse when you're sleeping on a train or something like that, and you're sitting there waking up, and you could just see that you drool down your shirt. So yeah, I had it. I had my. Do you call them wisdom teeth?
The back ones, yeah.
Yeah, I had. I think I had the two lower ones yanked out when I was in the Navy, and then was sent home. It was on a Friday, and I went home on weekend, and he had just shot me up with numbing medication and put in some cotton things. And I was sitting there in the train, and I couldn't feel my mouth because he just yanked out my teeth and filled with tranquilizers. And there was some kids who jumped on at a train station near a school. They were just looking at me, and I was didn't know what was going on. I might have been drinking the day before too. Could have happened. And I went to the toilet, and I just had before I had a beard, and I had 2 red stripes running down my my chin because I've just been drooling. I couldn't feel anything because it was just numb. So yeah, that was a fun day. Oh yeah, that's not good either. Well, you get some of the best sleep in church.
In church?
Yeah, because you just have to stand up and sit down on the right time. You all Fuba, yeah, we shouldn't talk about sleep about Fuba around Fuba because she hasn't slept since she started following my channel.
I know, I feel bad. So many people in
No, you
different time
shouldn't. She's
zones.
happy that she follows our channel. I did have an oral period. Every kid has that. I believe is it 3 to 6 months? That's the oral period. Oral period.
Is a what?
Yeah,
period?
nothing better than someone commentating on something 5 minutes ago. Am I going to take little D to kudos? Do I have to Google kudos, or is it something I shouldn't know? Well, it's kind of like doing this. That's why I think I'm okay at it, because I'm used to doing it in court. But it's so boring sometimes, especially when you have some story where it's. When I had done my first year of jury duty, we had an old judge in fun saying, "There's always only 4 excuses why they do anything. Do you hear a new excuse that's not some variation of these 4? You must acquit them instantly." And after 13 years, he's right. There are always 4 excuses. It wasn't me. I didn't mean to. I was drunk. It was an accident. It's always one of these 4 excuses that people use in court in some way or fashion. So
Okay.
I haven't heard any new ones. I heard a lot of iterations of the same one. But if you have some of these defendants who think they are the smartest one in the room and can talk themselves out of something, and they just keep on going and going and going and don't answer anything but just talk for hours, whew, that's a bit tougher. But you need a butt that's used to getting numb. And you went to the dentist today. Well, maybe you could sleep in the dentist chair. If Freud has anything to say, it's something with your mother. Do you know who Freud were, Jamie?
Tell me about it.
No, I just asked if you know who Freud is.
Hmm.
I thought, well, I don't know if that's good or bad that Beth falls asleep listening to us, Jamie. You've been on 2 juries, but they only a few hours long, and I survived. Yeah, and it's a different thing when you have to do it, because now you can just put this on your TV. You can sit and do your taxes. I don't know if it's tax season.
Do your taxes.
Knit, bake a bread, clean your windows, all the stuff I don't do because I should be doing it. I have to fix that faucet. I fucked it up again, Jamie. I have a plumber living next to me. I have to talk to him. But
That's sweet.
I have to talk to him. I haven't done it yet, but I messed it up yesterday. But yeah, as long as you can get up and move, it's not as bad as just sitting here. Sometimes a cigar is just a cigar. Ce n'est pas un pipe.
Would expect both sides to each go for an hour. There you go. Debbie Lang, thank you so much. We're going inside this courtroom, closing arguments moments away now.
Yeah. My mom would always knit when she watched stuff. I don't know. I think it could be a good thing, but probably a little bit too dangerous.
Please be. Seems like it is if he's up there.
All right, members of the jury, good morning.
Morning.
We are ready to deliver the jury instructions, and then the attorneys will make their closing arguments. Here's how the day will work. I will deliver the jury instructions to you. That'll take some time. I will have them displayed up on the board so you can follow along, but I will read them aloud in case you prefer to listen. After that, Mr. Anderson will deliver the state's closing argument. We'll take about a 15-minute break, and then Mr. Troffesy will deliver Mr. Mew's closing argument, and then the state will have the opportunity for a brief rebuttal. After that, you'll begin your deliberations. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether Mr. Mew is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The state filed an information that alleges that Nikolai Mew committed crimes in St. Croix County, Wisconsin, on July 30, 2022. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against Mr. Mew in any way. It does not raise any inference of guilt. In count 1 of the information, Nikolai Mew is charged with first-degree intentional homicide, and you must consider whether he is guilty of that offense. If you are not satisfied that Mr. Mew is guilty of first-degree intentional homicide, you must consider whether or not he is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of a life of another human being. The degree of homicide defined by law depends on the facts and the circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements that are common to each crime.
Sorry, Rachel, for yesterday.
Both intentional and reckless homicide require that Mr. Mew caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that Mr. Mew acted with intent to kill. First and second degree reckless homicide require that Mr. Mew acted recklessly. First degree reckless homicide requires proof of one additional element, that the circumstances of Mr. Mew's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense.
Yes, Cowpoke, and that's the big problem. Either you stick with what you think he did, or you charge him with all of this. Why put it in the 5 minutes till closing? That's what I don't like, because then you get compromise verdicts.
Defense in deciding which crime, if any, Mr. Mew has committed. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what he reasonably believes to be an unlawful interference with his person by the other person. However, he may intentionally use only such force as he reasonably believes is necessary to prevent or terminate the interference. He may not intentionally use force that is intended or likely to cause death unless he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. The words great bodily harm means injury which creates a substantial risk of death or which causes serious, permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. There is no duty to retreat. However, in determining whether Mr. Mew reasonably believed the amount of force used was necessary to prevent or terminate the interference, you may consider whether Mr. Mew had the opportunity to retreat with safety, whether such retreat was feasible, and whether Mr. Mew knew of the opportunity to retreat. You should also consider whether Mr. Mew provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against that attack. However, if the attack that follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he reasonably believes he has exhausted every other reasonable means to escape from or otherwise avoid death or great bodily harm. As applied to this case, the effect of the law of self-defense is Mr. Mew is not guilty of any homicide offense if he reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of second-degree intentional homicide
Hey, Mo Raiders.
if he caused the death of Isaac
Welcome, Mo
Schumann
peeps.
with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Mew is guilty of first-degree intentional homicide if he caused the death of Isaac Schumann with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of first-degree reckless homicide if he caused the death of Isaac Schumann by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life. Mr. Mew is guilty of second-degree reckless homicide if he caused the death of Isaac Schumann by criminally reckless conduct.
Hey, Wolfie.
You will be asked to consider the privilege of self-defense in deciding
all
whether the
Raiders.
elements of first and second-degree reckless homicide are present. Because the law provides that it is the state's burden to
It's if the knife didn't jab, you don't get a stab. That's what we're saying in this case.
What? Oh, you're
prove
hilarious.
all facts necessary to constitute a crime beyond a reasonable doubt,
Hey,
you will
Mama.
not be asked to make a separate finding of whether Mr. Mew acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second degree intentional homicide or for first or second degree reckless homicide.
Oh my God.
If
Adding all
the
this
state does not
BS is
satisfy
just
you that
stupid.
those facts are established by the evidence, you will be instructed to find Mr. Mew not guilty. The facts necessary to constitute each crime will now be defined to you in greater detail. First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first degree intentional homicide also requires that Mr. Mew did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself.
What he believed.
Before you may find Mr. Mew guilty of first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following elements were present. First, Mr. Mew caused the death of Isaac Schumann. The word cause means that Mr. Mew's act was a substantial factor in producing the death. Second, Mr. Mew acted with the intent to kill Isaac Schumann. Third, Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. The words intent to kill means that Mr. Mew had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being.
Doesn't matter.
While the law requires that Mr. Mew acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act. It must continue to exist at the time of the act.
Hey, Carlos.
You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not.
These jury instructions, I already zoned out because it's a ton of words. This is what's wrong with lawyers. These jury instructions, the blueprint or whatever, the skeleton of them are made by a jury instruction committee of 10 lawyers who all sat there and said, well, maybe we should remember to, and maybe we should put that in. Why isn't it just, these are the charges, homicide in the first degree, trying to avoid YouTube, is these elements must be present. Second degree, boom, boom, boom. It's always a 10-page word salad. At least he's reading it slowly. But still, it's just word salad because lawyers sit there and think, well, I have to make sure this won't happen and this won't happen. No one listens.
Motive refers to a person's reason for doing something.
50,
While
50,
motive may be shown
and,
as a circumstance to aid
mostly
in establishing the guilt of a defendant,
or 50
the
plus.
state is not required to prove Mr. Mew's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that Mr. Mew did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires the state to prove either, one, that Mr. Mew did not actually believe he was in imminent danger of death or great bodily harm, or two, that Mr. Mew did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When first-degree intentional homicide is considered, the reasonableness of Mr. Mew's belief is not an issue.
I think this is the first trial you'll follow with us. We always do. How do you think before the jury, then after the lawyers, and when they go on verdict, we do a verdict watch prediction.
You are not to be concerned. I'll start over. You are to be concerned only with what Mr. Mew actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Mew is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Mew caused Isaac Schumann's death with the intent to kill, and that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of first-degree intentional homicide, and you must consider whether he is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether Mr. Mew is guilty of second-degree intentional homicide.
No, that's a 25-year sentence. Well, that's what I read.
Before you may find Mr. Mew guilty of second-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the
Once Nicholas Starro, if you don't know him, follow him. He's Swedish, but he's okay. He had a case where a man was alleged to have unalived his missing daughter, and he was dismissed. That's the only case I think. It's a unicorn. They just don't exist.
Yeah.
But it happens, but very rarely.
following three elements were present. First, Mr. Mew caused the death of Isaac Schumann. Second, Mr. Mew acted with the intent to kill Isaac Schumann. Third, Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions
Closing
of causing
hasn't
death
started yet, Shelby.
and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. One, that a reasonable person in the circumstances of Mr. Mew would not have believed that he was preventing or terminating an unlawful interference with his person. Or two, that a reasonable person in the circumstances of Mr. Mew would not have believed he was in danger of imminent death or great bodily harm. Or three, that a reasonable person in the circumstances of Mr. Mew would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Mew's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Mew's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Mew's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Mr. Mew guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Mew is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Mew guilty of first-degree reckless homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew caused the death of Isaac Schumann. The word cause means that Mr. Mew's act was a substantial factor in producing the death. Second, Mr. Mew caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or
Yeah, he
great
has
bodily
a
harm to another
website
person,
dedicated to
and
it.
the risk of death or great bodily harm was unreasonable and substantial, and Mr. Mew was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Mew's conduct created an unreasonable risk to another. If Mr. Mew was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. The third element, the circumstances of Mr. Mew's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Mew was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Mew's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Mew's conduct showed utter disregard for human life. Consider also Mr. Mew's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann by criminally reckless conduct and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide. If you are not so satisfied, you must not find him guilty of first-degree reckless homicide, and you should consider whether he is guilty of second-degree reckless homicide, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Mew is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in section
No, the judge said he
940.06
didn't see it.
of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being.
You're not
The
the
difference
only one.
between first and second-degree reckless homicide is that first-degree offense
Hey, man, I
requires
just
proof
found
of one
out I can
additional
reach
element,
my bed with my
that the circumstances of Mr. Mew's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Mew guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann by criminally reckless conduct, you should find him guilty of second-degree reckless homicide. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Mew guilty of more than one of those foregoing offenses. Mr. Mew is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Riley Madison in count 5. For each count, you must first consider whether Mr. Mew is guilty of attempted first-degree intentional homicide. If you are not satisfied that Mr. Mew is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide, or first-degree recklessly endangering safety, or second-degree recklessly endangering safety, which are less serious degrees of attempted criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide and first and second-degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second-degree intentional homicide require that Mr. Mew intended to kill another person, and Mr. Mew did acts toward the commission of that crime, which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim, except for the intervention of another person or some extraneous factor. First and second-degree recklessly endangering safety requires proof that Mr. Mew recklessly endangered the safety of another human. First-degree recklessly endangering safety requires proof of one additional element: that the circumstances of Mr. Mew's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Mew has committed. For count 1, you were instructed on the law of self-defense. The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved in this case, the effect of the law of self-defense is as follows.
No. Oh, we're caught up now.
Mr. Mew is not guilty of either attempted first or second-degree intentional homicide or first or second-degree recklessly endangering safety if he, 1, reasonably believed that he was preventing
That's a
or
surprise.
terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Mew is guilty of attempted first-degree intentional homicide if he did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of first-degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Mew is guilty of second-degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr. Mew acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide or first or second degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed
Thank you,
to find Mr.
JC,
Mew
for
not
becoming a
guilty.
new member.
The elements of each crime will now
Even
be
if
defined to you
Jamie laughed
in
at
greater
you,
detail.
you chose to become a
Oh,
member.
was that what you were talking about earlier?
Before you
Yeah.
may find Mr. Mew guilty of attempted first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt
I
that
was
the
laughing
following
about all the
3
senior
elements were present.
citizens on the jury.
First, Mr. Mew intended to kill the named person. For
Oh my
count
God.
2, the state must prove Mr. Mew
Well,
intended to
there will
kill
be a hearing
Alexander
about
Martin. For count 3, the state must prove that Mr. Mew intended to kill Dante Carlson. For count 4, the state must prove that Mr. Mew intended to kill Anthony Carlson.
There was no intent in any
For
of it.
count 5,
No.
the state must prove that Mr. Mew intended to kill Riley Madison.
Well,
Don't you think if he intended
Intent to
it, they
kill
would
means that
be?
Mr. Mew had the mental purpose
yeah.
to take the life of another human being or was aware that his conduct was
Chat is
practically
saying
certain to
guilty
cause
on
the
this
death
included
of another human being.
47%, not guilty 28, hung 12%,
Second
and
element,
guilty on all counts
Mr.
11.
Mew did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another
Thank you,
person
Casey. Free
or
Mr.
some
Mew.
other extraneous factor. Unequivocally means that no other interference or, I'll start over. Unequivocally means that no other inference or conclusion can reasonably
much,
and
Casey.
fairly be drawn from Mr. Mew's acts under the circumstances. Another person means anyone but Mr. Mew and may include the intended victim. An extraneous factor is something outside Mr. Mew's knowledge or control. The third element, Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. While the law requires that Mr. Mew acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute.
I think it's 60.
There need
in
not be
Denmark.
any appreciable
Isn't it like
time between the
65?
formation of the intent
Maybe
and
it's
the act.
65.
Because that's when we get
The
like
intent to
Medicare.
kill may be formed at any time before the act,
But you get to be
including
get
the
in
instant
that,
before the act, and must continue to exist at the
group
time
of
of the
older
act.
people at 60, don't you?
You cannot look into a
65 is the
person's mind to
Medicare
find
age.
intent.
Hey, my
Intent to
pal
kill
Sal,
must be
give me a
found,
minute.
if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive.
Well,
While
take,
proof of
take
intent is
5
necessary
minutes
to
on
a
the
conviction,
couch now and again.
proof of motive
so
is
you'll feel
not.
better.
Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Mew's motive in order to convict.
65.
Evidence of
62
motive does not by
plus
itself
senior.
establish guilt.
Mhm.
You should give it the weight you believe it deserves under all of the circumstances.
Sequit attitudes.
The third element of attempted first-degree intentional homicide
The judge
requires
ruled
that
against
Mr.
it.
Mew did not actually believe that the force used.
You missed something, jury. No, you didn't miss anything, jury. There was a motion to have a jury member removed because apparently the lead investigator was observing her doing the video testimony yesterday, and they said she was nodding off and waking up, nodding off and waking up. The judge said, I was looking, didn't see it. And again, it seemed very, very sketch. It was that skunk-haired guy who sits next to the DA's table. But the judge said, nope, ain't gonna happen. Can the jury request a dictionary? Well, they get them back to read it. Yeah, it takes forever.
Was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Mew did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent death, or 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of Mr. Mew's belief is not an issue. You are to be concerned only with what Mr. Mew actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Mew is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Mew intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Riley Madison for count 5, and that Mr. Mew's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some other extraneous factor, and that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted first-degree intentional homicide, and you must consider whether Mr. Mew is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide.
I've already fell
However,
asleep.
if after a
20
full and
minutes.
complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Mew is guilty of attempted second-degree intentional homicide. Before you may find Mr. Mew guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present.
What are they?
First, Mr. Mew intended to kill the named person. Second, Mr. Mew did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person, except for the intervention of another person or some extraneous factor. Third, Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide.
Stop.
The third element of attempted second-degree
All these
intentional
words.
homicide requires that Mr. Mew not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. One, that a reasonable person in Mr. Mew's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person. Or two, that a reasonable person in Mr. Mew's circumstances would not have believed he was in danger of imminent death or great bodily harm. Or three, that a reasonable person in Mr. Mew's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In
And we're caught up again.
determining whether Mr. Mew's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Mew's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Mew's beliefs must be determined from the standpoint of Mr. Mew at the time of his acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Mew intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Riley Madison for count 5, and that Mr. Mew's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Mew is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Mew is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Mew guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew endangered the safety of another human being. Second, Mr. Mew endangered the safety of another by Mr. Mew endangered the safety of another
Hey, little
by
D.
criminally reckless conduct.
Little D, expert asked me if you were taking me to Kudos. I don't know what that is.
Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Mew was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should also consider the evidence relating to self-defense in deciding whether Mr. Mew's conduct created an unreasonable risk to another. If Mr. Mew was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The
Kudos.
third element,
Kudos.
the circumstances of Mr. Mew's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors.
No, Chrissy, you have missed an hour's talk about jury instructions. I don't know. There are 25 pages. I stopped listening an hour, 45 minutes ago. You missed nothing.
What Mr. Mew was doing, why he was engaged in that conduct, how dangerous.
It's the Dukes of Hazzard's place that's called Kudos. It's not Hooters, like the owl. It's Cooters. Yeah. This is all the kids' faults. Yeah, they need a lawyer in there to explain all the fancy words.
The conduct was, how obvious the danger was,
I don't think you go to Hooters for the food.
whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. We should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Mew's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Mew's conduct showed utter disregard for human life. Consider also Mr. Mew's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt that Mr. Mew recklessly endangered the safety of another, those named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, and Riley Madison count 5. and the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Mew is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in section
white women?
941.30, parent 2 of the Criminal Code of Wisconsin,
I do too.
You prefer big white women too?
Buffalo Wild Wings.
Oh,
I didn't hear the first part. I was zoning
sometimes you
out.
should listen to my chat, Jamie.
Oops. Big white women.
It's because BBC is British Broadcasting Corporation and something else.
Oh,
So I
man.
thought, well, to each their own. Maybe it's why Carissa likes big white women.
Carissa. It fits so well together too.
Yeah.
Murderers, big white women, you know. Okay. Oh, that's funny.
Yeah, we needed a little laughy laugh.
Were you being
Corporation.
serious? Did you not know?
We don't have Buffalo Wild Wings in Denmark.
Okay.
I never
Okay.
had never had a chicken wing in my life because I don't
you
like
hate
chicken.
Yeah, he hates chicken.
I've
guys.
eaten at KFC. That's the worst food I ever had.
is committed by one who recklessly causes the death of another human being. The differences between first and second degree recklessly endangering safety is that the first degree offense requires proof of one additional element, that the circumstances of Mr. Mew's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Mew guilty of second degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Mew endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Riley Madison by criminally reckless conduct.
Lefty, I don't even think you can count up to C in the alphabet.
What is he talking about?
You should find him guilty of second degree recklessly endangering safety.
What did I
If you are
miss?
not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Mew guilty of more than one of the foregoing offenses for each count.
Yeah, always shut up.
Yes, please take the jury out.
All rise for the jury.
Finally, your instructions over, so we can move on to the closing statements from the state.
Why are they taking them
Finally.
out?
Because the state needs a break so they can get their stuff in order. They were sleeping 5 minutes ago.
Okay. Okay.
Let's return in 5 minutes, 9:40.
Oh my goodness.
The primary charge coming into this case on the it's called the criminal-
Every now and then I get a little bit bored when they read so much to me. Whew. If he is found guilty, does the time spent listening to the judge give instruction count as time served? No, I think that should be, you should time whatever he did by the minutes the judge just spent.
Mhm.
If I get it correctly, he's been reading jury instructions. I can see it over here. He's been reading jury instructions for 50 minutes. That's 6 minutes less than the entire interview with a buckle swap lasted in prison. Whew. It takes skills to eat flats. No. And you would be crying after.
Oh my God, stop it.
We're going to be shirts off and going at each other as two old male elephants. Mostly because we're both fat, but
Are you calling Lefty fat?
But luckily, there's a time limit on closing arguments.
Oh, I got it.
Flats are so much better, no tendons and BS, just pure goodness. But they'll never give me all flats. I don't know what flats are.
They're the chicken wing things.
I never had a chicken wing, Jamie, so how should I know what a chicken wing thing is? I agree. Well, it's because Jamie, I think she's watching something else.
No, I don't know what I'm laughing about half the time anyway. Usually I think of stuff and it just makes me laugh.
She's sitting there saying, it's chicken wings. I said twice on the show, I don't know what chicken wings really. Yeah, I know what a chicken wing is, but I never had it. It's a chicken wing thing. Okay.
Yeah,
We
it's
will,
a chicken wing thing, duh.
We'll go at each other like Dusty and Ric Flair in the olden days. No, we still haven't had opening statements. Closing statements, sorry. Flats for the win. I shouldn't be Googling anything.
It's
Is it
not
fried?
bad. No, it's the wing. I keep doing that like it matters.
Adelaide, not in a million years. How have I never had a chicken wing? I've eaten a roasted chicken. Of course I have. So I have had the arm of a chicken.
I've ate a roasted chicken.
But I back in the day we had what's called Saturday chicken. It was just a very, very poor chicken that it came in a folio thing, so you can just put it in the oven. That's it. We ate that a lot as kids. It wasn't good, no meat on it, but it was cheap and we were poor. And then I had salmonella poisoning when I was 18, and I can eat chicken nuggets because I know there's nothing resembling chicken in those. So, but other than that, I'm not a fan of chicken.
Yeah, you need to try it again. Like, you need somebody to cook for you when you come to the US.
Only if you get enough suction. One side of chicken wing is the drumstick, the other one is the flat. Na, 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 na. Well, I don't even remember what I got at KFC. I just remember it's really, really bad. Because I thought when you had like these deep fried chickens, they should be crunchy. And it was, did I had something with cornflakes in the breading? I think there was something with cornflakes in the breading. Well, it was really, really bad. I eaten chicken, but I had salmonella poisoning when I was 18, so I haven't eaten it much since. Even on dry land, if you and your beer bus pals are shouting PDF file at an unknown person, you are endangering that person. Some people will kill a person that other people, yeah. There's a lot of trouble in this one. Foodie page on Discord. It's fried chicken. I'm so far behind. Chicken wings are both salts. Have you met each other in real life, or will you meet next month? No, Jamie doesn't want to meet with me. She likes to keep the magic, as she says.
The mystery.
Yeah. I'm her tall, dark stranger, even though I'm blonde and not that tall. Oh, I don't know. Nope.
I'm picking up on page 20.
Oh, he's not done, Jamie.
Oh, Jesus Christ.
Yeah, I tried it twice in Copenhagen.
In
Pretty
count
bad.
6 of the information, the judge alleged that Mr. Mew committed battery. Battery, as defined in section 940.19
I'm taking
parent
a
1
bio break.
of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Mew guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 4 elements were present.
Judge, can we approach quick?
Yes?
Oh my God. I have 38 pages of this. This is ridiculous. Sheriff seeing his glasses on his head all the time. It's so
Every
ridiculous.
lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Mew committed battery. So let me get to the elements. First, Mr. Mew caused bodily harm to Madison Cohen. The word cause means that Mr. Mew's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Mew intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Mew had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Mew caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Mew knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved and that Mr. Mew did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Mew committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Mew guilty on any of these counts, you must answer the following question. Did Mr. Mew commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Mew committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is
Exactly,
overcome
Volstorm.
by evidence that satisfies you beyond a reasonable doubt that Mr. Mew is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Mew is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Mew's.
What do I think so far? That there's way too many jury instructions and no one is listening. And that my friend snooker bar is really good. I think he will be convicted because the state put in all those lesser included yesterday, but I don't think they proved in their case.
Innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork.
In
or
Florida, they would
speculation.
be launching, probably laughing
A
about
doubt
a
which
3-inch
arises
knife as
merely from
dangerous with a
sympathy
weapon. But the state
or
will
from
charge you
fear to
anyway
return
if
a
they feel
verdict
like
of
it.
guilt
Thank
is
you so
not
much,
a
Tracy.
reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Mew the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Mew the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or
Tracy,
circumstantial,
boys,
it
have
must
stand your
satisfy
ground.
you beyond a reasonable doubt.
Yeah, but again,
that
if
Mr.
the
Mew
state
committed the
feels like
offense
if we saw
before
that
being
in
found
the
guilty.
treehouse, they'll make up anything
Evidence has been
if they
presented
feel like
relating to Mr.
convicting
Mew's
you.
conduct
Sadly,
after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence.
My cat's
If
snoring.
their remarks
I'm
suggested certain
surprised
facts
you
not
can't
in
hear
evidence,
that.
disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions
Well,
asked of
he
witnesses
needed 5 more
and to the
pages.
admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack.
Yes, he has a whole website dedicated to him, calling him the PDF file judge. I looked a little bit on it yesterday. People are not fond of him.
Lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence.
Not the closing
Draw
argument.
your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you.
Anyone who just came in, welcome. The rest of us have been going for an hour and 30 minutes through jury instructions. I can't tell you what they say because I've zoned out an hour and 15 minutes ago.
So they basically charged him with every charge known to man.
Yeah.
And they're just whatever
From
sticks.
J1 to murder one.
Yeah.
I know Court TV released parts of the transcript. Marissa is still trying to get it. She called court, still nothing. I want to see the full context. I want to read it if I can get it. I don't like just taking snippets out here and there. But apparently she couldn't tell her left from her right is what I saw. Why do we need 100 pages of jury instructions? Because these are made by lawyers. Lawyers talk too much. kind of like me.
By the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Shirafisi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge.
Oh, God.
Absolutely senseless and horrific acts of violence.
And
And all Nikolai Mune had to do was walk away.
No,
All he had to do was walk away. That's what you've seen. in this
already
case.
out the gate. I
You
know
saw he
that.
told Lieutenant Hart, they told me I can't run away. Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, I stood my ground. I stood my ground. First of all, Wisconsin is not a stand your ground state. Objection.
Overruled.
It's not what he
I'll talk about that
said at
specifically
all.
from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nikolai. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nikolai did. You heard from Elena, Isaac's mother, about her son Isaac. He was 17 years old when he was.
that doesn't matter. Her mother wasn't there. She can't testify to shit. This is just to pull the heartstrings, and I hate he could just have walked away. It's not a prerequisite in the law that you must walk away. I'm going to
boys
lose
didn't
my
have to
temper.
follow. There's a lot of things that could have, should have,
Yeah.
would have, should have.
Yeah.
Killed. He enjoyed golfing, spending time with friends. He recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nikolai would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nikolai is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Jawan's video. It's grainy, it's difficult to see, but you can see enough.
But what is it supposed to show otherwise?
And it
sir?
shows Nikolai seeking Dante out and stabbing him. When
Seeking him out.
It took 16 seconds. He was seeking him out. He ran around poking all of them, saying, hey, sorry, can I get to Dante? I really hope Shevardowski is coming in because this is absurd. This is absurd. I'm sorry. The judge doesn't have to, it's not testimony, it's just closing arguments. If there's no objection, everything goes.
This group is in the opposite direction. Nikolai walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video.
Take it off.
Good one, Sean Bird.
Clear the screen, please. So here at 2 minutes and 6 seconds, this is after Nikolai has stabbed the 4 people that you do see parts of on video. He's standing next to Ariel. Ariel's there. Nikolai's not by himself. Two minutes, 8 seconds. That's the last you'll see of Nikolai until you see him walking off in this video. You see Dante or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nikolai was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed.
It's to show the emotions of the friends of the dead kid.
Next, you see of Nikolai. He's walking off.
This is a shitty movie.
You can see Dante in the background, holding his stomach, looking down at his wound. Take it down. Oh, actually, you can keep it up for a second. Sorry. And then for further context, you see Alex Bang running to Isaac. Let's see Larian's video. Okay, I have the screen. Remember, Nikolai admitted he walked up to Larian. He walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nikolai, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom.
Where?
You'll see Nikolai walk up to Dante and stab him in the chest.
Where? Which person is what?
You'll see Dante recoil from the stab.
I can't see
See
anything.
the
I
boys
can
on the
see two
right
people
running to
coming
their
together.
tubes. And in the second here, you'll see Alex Bang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nikolai and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nikolai, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense.
What is he talking about? I'm getting mad. Trying to make
Yeah.
coffee and you're sounding like an idiot, dude.
And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA, how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nikolai's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nikolai punched Madison. She has zero connection with the group anymore, zero contact.
The same girl who said, I couldn't see anything because there was so
Tony
many
is another
people in
one.
front of me."
He only comes in to break up what he thinks is a fist fight. He's directing Nikolai towards Nikolai's group. Nikolai turns and stabs him twice. Another one I submit to is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nikolai to leave. In the middle, when Nikolai turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nikolai, Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there.
He's having a 2.19 alcohol level.
And he didn't get the poke until he had his hands
There's
around
been
his neck.
Yeah,
pretty serious
exactly.
mischaracterization of Isaac's actions with regard to when he
Exactly,
gets stabbed.
Chamalalakata.
Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the
Yep.
frames,
Yep.
to try to show a certain
Yeah.
narrative about Nikolai smiling.
you
As
did.
you've seen, he's smiling a lot in the video.
He's not smiling
But
you.
He's not
defense is
smiling.
actually doing that when it comes to
At
Isaac.
Ark.
Nikolai never said anything about being choked, never said anything about pain on his neck. Even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie.
If somebody's going
So,
for your
on the
neck
left,
in a fight,
Nikolai has just stabbed Riley, who you
You have
heard from
every
multiple
right.
witnesses who are just standing there.
Yeah.
Tony comes to try to break it up. Nikolai stabs him twice. Isaac, just off frame, I submit to you, he just saw Nikolai stab those two people completely unprovoked.
You have
Although
no
he's in
evidence
the
of
background the
that.
whole time, not doing anything,
unprovoked.
he came to their aid. And he pushes Nikolai. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nikolai's own action of thrusting the knife into Isaac's heart that moves Isaac's hands.
No.
You can even
The F, it's his trusting into his heart that moves his hands. Go back a picture. He has his, again, you're taking 6 pictures out of 24 pictures in a second. He has his hand moving. It's not here. And then he is stabbed.
It's
And
not
it moves.
pictures. It's not going slowly where it's like,
It's going for
Coming
his
to you
neck. And then
slowly. Yeah.
Jamie, I hate this.
see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion.
you're an idiot,
Let me take this
guy,
screen down.
dude. Come on.
I'm going to show you the video so you can see it's obviously a push.
It's not what you think it was. It's what Nick thinks it was in the moment. You
Yeah.
idiot.
While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nikolai stab
So
two people
was Nick.
who posed no threat to Nikolai. Tony was breaking up the fight. He had actually ignored Nikolai at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push.
So hurry, play it in slow motion. You know.
Defense has mischaracterized the entire situation as 13 on 1, 13 on 1, implying it's some sort of mob beating up Nikolai. It's not even 13 people yelling at Nikolai. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the
He doesn't
background.
know how
not
many is
anything.
yelling at him. They are all
It's 13 people in the proximity, only 2 close to him, 2 tiny females.
Tiny. Oh, he wants to say, there we go.
Nikolai's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. So it's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13 on 1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense.
Not really.
This is the second time you saw in the video that Nikolai turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife.
Okay. And that means he's angry because you know him
The
so
defense
well.
tried to explain that change from in that 30-second window
Look how he's laughing.
by saying he was getting pushed by Madison and Ryan.
Yeah, that's
He was getting
assault.
pushed. They're lightly touching his arms and they're tiny.
Lightly?
They're not in his face. You can see in the images. They're
Doesn't
standing
matter.
close. They're not in his face.
That is
They're
close
not
enough.
shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing,
And they shouldn't
yelling at him
be.
to leave.
And they shouldn't be. They don't know this guy.
I'm going to back up a little bit and talk about Nikolai looking for the phone. So Eric Von Williams from Nikolai's group, you heard testify, before any of this happened, he was concerned about Nikolai's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nikolai not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nikolai went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys.
And why is that illegal? Why
Defense
can't you
argued
get
in
off the
opening
scooter
that
and go somewhere?
the boys' goal, their goal was to humiliate Nikolai.
Yeah.
Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing.
Yeah, they
They
were.
reacted wrong, but they just didn't invent this whole thing in order to humiliate Nikolai.
You don't think so? Really?
What about Nikolai,
You can
52
hide?
years old, apparently sober, according to,
Apparently,
I think, what defense will argue.
he's not
What did he
apparently
say?
sober. He's sober. As I said yesterday, if you have a DUI, it's not because you were driving drunk. It was because someone took a breathalyzer and found out, oh, you're drunk. A lot of people drive drunk every day. They're not DUIing because that's a legal term. He wasn't apparently drunk. They didn't prove he was drunk, so he was sober. Oh, Jamie.
And people can have a few beers and not be drunk. I mean,
And
not
they
David,
can,
but
they can have 45 beers and
Yeah.
be so hammered, but in a court of law, if they don't take him in to take a blood test, he is sober.
yeah.
Sober.
Mhm.
Because everyone who's drunk driving is the people who are caught. Everyone who steals in a shop are only breaking the law when they are caught. No, they're breaking the law all the time. Yeah, but they're not caught.
Mhm.
So they can do it again. There's no consequences unless you're caught. Fucking. Oh, sorry.
He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was boozing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nikolai has to do is stand there.
He's
He
in
doesn't
front
even
of
have
them.
to take a step back. He just
Idiot.
has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them.
Touches his knife. Quit
You heard
saying
Nikolai's
that. Like,
ridiculous
you know.
description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nikolai had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nikolai is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy. He was in the army. He doesn't need a knife to defend himself. He didn't say, oh, he's this fragile
When
big
was
guy.
Yeah,
Wait. What?
He's clearly not feeble, as you see.
He's not. Okay, when was he in the army?
He was never in the army. He thought because he had been in a communist country, he had been in the army. He never was in the army. No proof of that is presented.
But unless he was in the army after he had heart surgery, that makes no sense at all. to even
I was
bring
in
that
the
up.
army. I left the army 21 years ago, which is pretty impressive as I'm 27 years old. I'm not sure I could hit the side of a barn with a gun. I've shot maybe 10 times in those 20 years. I couldn't field dress anything. I couldn't. Yeah, I'm still a trained soldier, but I couldn't do any of the stuff I could back then. I have 2 herniated discs and nerve damage. It's not like I'm a spring chicken. And there was 13 people. Yeah, but not everyone was yelling. He doesn't know that. He doesn't know who punched him, and he was punched repeatedly. Yeah, they should have objected to that and say, come on, brother.
Well, they're not gonna, because it was testified to, but they're letting them twist their little words. He'll come back with it.
He was a young communist because he was 15 when he left, and it was under the good old Ceausescu days. So he has been a young pioneer, as they were called. Well, that was East Germany. I don't know what it was called in Romania.
See in the video, he runs up on these boys in the water. He leaves behind devastating injuries. Slices clean through 2 of Isaac's ribs.
Slices.
He comes out of the whole event essentially uninjured. While defense tries to argue that Nikolai is this feeble old man, they ignore that the only 2 people actually standing close to Nikolai are these 2 females that are barely over 100 pounds.
So what? They're half his age.
If the boys are a threat, Why does Nikolai run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nikolai to try to explain this transition. From 0 fear to 10 out of 10 fear, he's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nikolai, the demonic look on his face, staring through people, smirking. Defense argued in opening, it's a slide to or here there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video.
He's not smirking.
What's smirking?
Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nikolai, I asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear?
Anyone. It's possible.
Nikolai was angry. He wasn't afraid.
He wasn't angry.
He's smirking even as he's holding the knife.
I'm angry.
Why didn't he just walk away? Defense tried to argue there's rocks in the stable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and respond to Nikolai punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nikolai just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nikolai did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm.
I disagree.
So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nikolai punched her. She fell backwards.
Beyond a reasonable
but
doubt
caught
where?
herself.
Show me.
Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing or on cross.
Well,
she's
doesn't
not
look
wet.
like she
She
fell
didn't actually fall
backwards.
down.
Looks like she turned around and screamed. She's screaming. She didn't fall anywhere. Where'd she fall? And who testified that they saw it? Because no one saw it. Not a single person.
Can I just show you a little thing I just noticed? I haven't noticed that before. She fell backwards. This is her position right now.
Yeah.
In this picture where she fell backwards, her position is this.
Yeah, it looks like she turned. She's turning her body.
She's turning around, yelling at group 2 over here.
Mm-hmm.
You're not falling backwards when you're bent forward at the hips.
Yeah.
You can say whatever you want. She goes from being straight up. Where the hell did that go? She went from facing that direction to facing that direction. That's not falling backwards. That's turn around. Every now and then I get a little bit punched in the face when I scream at a guy. Turn around. I still have my beer in my hand, so he didn't hit that hard, and I yelled to get more to hit him. That's just stupid. She fell backwards. You can see her hips down here. I think it's her hips. She's leaning forward. You're not leaning forward when you're falling backwards. She should be leaning backwards when she is falling backwards.
Well, that's
If
exactly what I was
witnesses are
thinking
all
over
standing
there.
in that kind of semicircle around Nikolai, she gets punched and falls backwards, and then their attention's back to Nikolai because Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. Her shoulder to shoulder in front
Right out of the
of
gutter.
Nikolai before the camera pans
Well,
away.
that can't happen.
When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore.
Where's her sunglasses on her head on the picture?
Where-
Defense has a double standard about that
Wait,
too.
wait,
If
wait.
there's not a photo of it, it didn't happen. There's not a photo of an injury, it didn't happen.
Where are her sunglasses?
We know Nikolai got punched. He didn't have any injury.
1
Were
hour.
they on her face? They could have easily fell off when she jerked her head over to scream at people because she's an a-hole.
I love he's showing the photo and comparing them, because which side should she have the markings on? The markings that she took photos of. The side of the face you can't see in that photo. And that face, as one who has been punched many a time and might even have punched someone in the face, that's not a girl who's been punched in the face. That's not crying eyes. Her eyes are open. If you just got slapped in the face so hard a guy could hear it and could clearly hear it was a punch to the
And you
face.
fell backwards.
Yeah, you would have your eyes closed and look more like you're about to cry. This lady is yelling. She's not yelling, hey! She's, get over here, start fighting.
Oops.
And you can see Riley is moving forward into Mr. Mew.
Defense can't have it both ways.
Neither can you stupid idiot.
Yeah.
So turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events going to affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nikolai did.
If he can make up a story, can I just show you the 3 statements all of your witnesses gave that was exactly the same statements?
Defenses tried to highlight throughout the trial, Nikolai was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who's disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nikolai, who invented an entire story, tried to skip through the crowd.
Yeah, the lies. I said the lies has come
Give him
back to
credence
him.
for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising. Some of the details are wrong. But the major point is accurate, is
K-Mac.
consistent. This all started when Nikolai punched Madison, whether it's the right hand or left hand.
No, it started when she put her hands on him.
You heard the turmoil of the boys
Assault is
when
assault
they
is
realize
assault.
Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. you and say your partner go to the grocery store. Park your car, you're leaving the grocery store, you think your car's parked over there, they think it's parked over here. You still know the car is parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the Boyce group, that Nikolai struck Madison. So let's talk a little bit about witnesses from Nikolai's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nikolai. Remember, Ariel was there when he stabbed Dante. He was right there when Nikolai stabbed Riley, Tony, and Isaac.
He was right there. He was
Law enforcement
behind
went
him.
there with the frame of Ariel standing next to Nikolai when Nikolai has the bloody knife. Ariel denies seeing
I
anything
hate this
to law
frame
enforcement
shit.
of what Nikolai did. Ernesto, at trial, testified he didn't see Nikolai get hit, just saw him down in the water.
Sorry,
Said he
someone-
couldn't remember Nikolai saying they took my knife. You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, get back. Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, Nikolai, get out, Nikolai walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question, but he described that event. He also wasn't asked more than 10 times if Nikolai said they took my knife. So, about the punch to Madison again. Sergio, he's in Nikolai's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nikolai and say, go, go, go. He said it repeatedly to law enforcement. And he said Nikolai pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nikolai do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nikolai just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, don't worry about it. This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nikolai's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Bang. Alex Bang originally described it as a slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say, I saw some swelling and some slight redness, but didn't see the punch? Why wouldn't he just say, yeah, I saw the punch too?
Well,
Why
why
would
didn't she just
Tony
take
say
pictures?
Because he was all
Why would
across the
Tony say
river,
he
you
saw Riley
idiot.
get stabbed and she's just standing.
Yeah.
They tried to explain what happened as best they could remember.
She had
The
pictures.
punch isn't on video,
She
but you
deleted
see
them.
the reaction. You hear Dante yell, you can't hit a woman before Riley is stabbed. They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nikolai in that half circle proximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the Carlson group. They all were wrong in what they saw.
They didn't see anything.
No.
Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nikolai's group in a different category. There's the drunks on the Apple River, then there's Nikolai's group. About half of you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go out, they tube, and they drink. Nikolai was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before.
He knew what it was about. He's been on a river before. So you should expect the next time you go tubing that some teenage will start a fight with you.
Yeah.
Sometimes you do take a beating. Did we
I
hear
have
that in
never-
the self-defense case?
Yeah. It has never been the case. I have never been on a river where people are just having brawls. Like, believe me.
Yeah, but those kids had been tubing before. They should know what it's about.
Yeah.
You get some
It's the
aeration when you start yelling
Those
at people.
mean river streets, man.
Another thing about the punch to Madison, you heard that they didn't get to see the video before giving their statements. Even Juwan, who took the video, said he got far enough to get the screenshot of Nikolai, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nikolai got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said. So, count 6 is battery to Madison Coleman. It has 4 elements. Nikolai caused the battery to Maddie, or caused the injury, the harm, the pain. She testified to that. He intended to cause the harm, despite his denial. I submit to you that's clear. You don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. He knew that. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, the knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nikolai's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Maddie and Riley are standing in front of him, lightly touching his shoulders.
Lightly is
People
still
are
a
pointing and
scope.
laughing, the boys. They're not, Maddie and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference. People yelling at him, Maddie and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do. Just walk away.
He had
Instead,
no
he
duty
takes
to
out his
retreat.
knife and punches Madison. Regardless of whether you were convinced beyond a reasonable doubt it was a punch, Nikolai essentially admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. Your jury instructions talk about provocation and how that affects self-defense. Person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nikolai ran up on these boys who were tubing away.
And they ran up on him.
They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, they took my snorkel.
50 minutes.
I'm going to play that for you so you can hear. All right, this is at 105 in the video. I'm ready.
Go, kids, go! Go! Go, kids, go! Go! Go, kids, go! Go!
They shouldn't be allowed to play this in a loop. And again, notice here, no one is close to him. They are walking up to him. He's not walking up to them.
Doesn't matter.
You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking the snorkel, which was a lie. And he had just ran up on the boys.
But he laughed at the situation.
So
they followed him.
After he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people.
Oh my God.
Takes out his knife. Either punches or pushes Maddie. That's provocation.
Either punches or pushes her now? I thought it was a punch, and it was undeniable.
Defense has zero reasonable argument. Especially when it comes to Tony, Riley, Isaac, and Dante. Nikolai gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nikolai.
He gets ineffectually pushed. What the hell is this?
It's just...
He gets pushed. You can clearly see that there's indents in his skin. Oh.
Pops right up. Disembowels AJ.
You got this.
After Nikolai goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nikolai down on the ground, Tony walks by Nikolai with his back to Nikolai, yelling, "Get back to Dante." He turns around to tell Nikolai to get away, and Nikolai turns around and stabs him. Nikolai was facing his group with an open path of escape after provoking a reaction.
After they attacked him.
He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you, the state has proven beyond a reasonable doubt this was not justified self-defense, and Nikolai knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at the definition of great bodily harm, whether he reasonably believes death or great bodily harm is imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believed that the force used was necessary to prevent death, imminent death, or great bodily harm. So for the intent to kill, but for outside circumstances. AJ, it's beyond clear. He would have died but for the blood in the helicopter. He would have died, but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nikolai's intent but to kill?
I can't remember from the Rittenhouse trial. Is Wisconsin one of those where they don't get rebuttals?
They get rebuttals.
What?
They get rebuttals.
They get, okay, because I thought he said 1 hour time limit, so he's running up on that. And he's
Because he
still
said
yapping.
short rebuttal.
Short rebuttal, thank you.
Yeah, he said
Slices
very short
him
rebuttal.
up like that. He had the knife blade up. That wasn't an accident. He did not know. The first thing he does with it is slice up AJ's stomach.
No.
Riley, he slashes across the ribs.
That's the in the
You saw
side.
the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nikolai stabbed him again. The one he blocked, you saw the injury, was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart.
Okay.
But for Nikolai missing vital organs, but for medical intervention. You claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified you heard about anytime there's a puncture wound to the torso, stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nikolai killed Isaac, almost killed AJ. Riley needed emergency surgery.
53
Luckily,
minutes.
but for dumb luck, he missed the vital organs of Dante. But for AJ blocking one strike and missing vital organs, he survived. Nikolai said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. It makes the tunnel vision claim a little bit unconvincing.
Why? Because he didn't stab all the
For
other
first degree
people. who
intentional
didn't
homicide,
come out.
Isaac Schumann, Nikolai stabbed him so hard, he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. And intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that.
That's
Did not actually
obvious.
believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all the ones. Third element, he did not reasonably believe the force was necessary. That also goes to, oh, sorry, that's part of the third element. So how do we know, what Nikolai believed? What a reasonable person would believe? That there's only one person on the planet who experienced what Nikolai experienced, saw what he saw, was standing in his place. And what did Nikolai believe? He believed it was unjustified. The very first thing he does is walk away, doesn't run, doesn't tell Ariel or Nestor anything, doesn't tell them to run. He walks away from his group to the other side of the river, at some point rinses the knife because it wasn't covered in blood. Throws the
No,
knife
he
on the group for walking
threw
back
it
to his
on
group.
the side of
Says
the
nothing to
bank.
his group other than they took my knife. Puts on his hat, sunglasses, and shirt, and sits down in his seat. He's the one, as he said in his interview, who says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw, so plan 1, get away, slink away with the crowd. That didn't work. Plan 2, play down. Can you take the screen down, please?
I'm not sure.
You better wrap it up.
Oh, look, now we're gonna watch a video.
Camera recording started.
Oh, they want to play the
Still doing all right?
video again.
Okay.
What's going
Temperature's okay in here?
Yeah.
Okay.
Somebody,
All
I hear somebody got stabbed,
right.
and I fit the description.
Yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
Calling each other names. That's, we've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know,
Okay.
kids
All right.
being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Can we like wrap it up?
And so I told Sheriff Knudsen, and he's acting like he has no idea what's going on. Clearly not in shock. Can you take it down a second? Clearly not in shock. Clearly Nikolai knows that it's not justified, and he's
He's
looking out.
clearly not in shock.
Slinking away didn't work. Playing dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he used, poke, with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nikolai actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it does make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. He's clearly not in shock.
He knew his actions weren't justified. Like,
Yeah,
okay,
yeah, he knew
Yeah.
that. Yeah.
he
The
knew.
use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Varial's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat.
We have been
Whether
going
there
for
was a safe
59
escape.
minutes.
He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison.
Gonna find out now.
Now he
He
punched
touched his knife when
Madison?
running up on the before running up on the boys. He takes out the knife, opens the blade up,
I thought
never
he
says
knew.
anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand.
Smirking.
Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nikolai did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene with chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the start nurse at 9 p.m., so 5 hours after the incident, about the boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when he clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nikolai was not in fear, he snapped. He was angry and he snapped, and he knew it. His actions show he knew he He did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? You know what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide and first-degree attempted homicide. His acts clearly show intent. But if you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nikolai's belief versus reasonable person. Here you know, I submit to you his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety.
He's
Element one,
positive.
Nikolai endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. The jury instructions define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and just stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there out there to disregard?
What about his life? What about the regard for his life?
He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims, and he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool. Totally fine to carry it for self-defense. Totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nikolai did not use. He was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nikolai knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schumann, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. Walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nikolai, his group's over here, would walk this way towards the group of people to stab Dante.
What? You are a
Senseless and horrific acts. The state has to find Nikolai guilty of all charges. Thank you.
Nothing you said.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
The definitions and the crime.
Sheriff EC's taking some notes.
I really hope he can do it in 45 minutes or less.
Mm-hmm.
It's the ending. The last 20 minutes, he was just rattling.
Yeah, about him just so angry, he's just going on a spree.
Yeah, you can't act in self-defense while being angry over being attacked. Yeah, because that takes away the right to defend yourself, that you are mad, you get punched.
He did the disregard for everybody else's life. That bothers me because it's like, what about his life? It's not about what anybody, it's about what he felt in that moment.
Yeah.
And he felt like they didn't give a crap about his life.
And again, his only reaction were people stepping to him.
Mm-hmm.
His reactions were not to go seek out people and just go apeshit. It was people stepping to him he responded to.
Mm-hmm.
Yeah, I would show that video in the beginning and say, count. This was how long he had to react. 11 people stood around him. One person knocked him down And from that, he was punched 3 times to the head. He was, someone grabbed him by the throat. And again, count to 16. That's the amount of time everything happened in.
Yeah, it
How
didn't
do you
happen.
think you would react in 16 seconds?
Yeah. Like, this is real time. This is not snippets of a video that you put up and say, well, look here, this is what,
Yeah.
it isn't like that in real time.
Yeah, and just go in there and say, Madison, the state can lie all they want and say she didn't do nothing. But in reality, she puts her hand on her. In Wisconsin, we call that assault. That girl assaulted him to begin with. Then Riley assaulted him, as you can clearly see in this frame. The state want you to not think about that because they are women. But in 2024, we don't see women as lesser beings anymore. We see them as equals. Those 2 women attacked our client. And he stood his ground, which you're allowed to do, and didn't do anything. Then the boys walked up on him. 11 people joined the 2 women who already laid their hands on him. He pulled out his knife. He didn't use it until he was punched 3 times, fell on the ground, was shoved down, and then they attacked him again when he came up. This guy who had a quadruple bypass, who was shoved in a river, in fear of drowning, did the only thing any reasonable person did. He feared for his life. Madison started this trial by assaulting our client, but he stood his ground. He didn't react. He wasn't angry, as the state claims. Then Riley attacked him. That didn't make him angry. He stood his ground. He didn't react. Not until they came so close to him. He fended for himself with his left arm, and then he was attacked by a mob of guys. Big, strong, young men. A defensive end, 235 pounds, now playing college ball. A safety, 200 and something pounds, now playing college football. All of them high out of their mind, all of them drunk, way above the legal limit, even though none of them legally could be drunk, attacked this man who they antagonized. This is clear self-defense. He was assaulted in this video, this frame, assaulted by Madison, this frame, assaulted by Riley, this frame, assaulted by AJ, this frame, assaulted by Dante, this frame. Sadly, AJ assaulted him, and the consequences of that assault was the passing, and Mr. Mew will have to live with that for the rest of his life, but he responded to a result. A response to a result is self-defense. Thank you so much. Watch the video again and count to 16. Or as Lefty calls it, all the time he can spend with his wife.
Oh man, throwing shade.
Exactly. Yeah, and use some demonstrative. Say, boop, boop, boop. This makes it self-defense. If they added an option for obstruction or something for the lies of as a lesser included, I could stand by that. They only didn't because they knew that's all he'd get if they did. Yeah. If the state could be honest, they would just say, who is more important to you, the fat old guy that had heart surgery or the 70-year-old golden-haired athlete that grew up in your community? That is probably right. Yeah, I should do TED Talks. What's a TED Talk?
Where you get on stage and you just like motivational speak to people about something.
Well, I don't know.
Jury will be in any minute. Then it's the defense turn to give their closing statements, closing arguments to this jury in Hudson, Wisconsin. We'll be quiet now. We'll see you after the closing arguments.
Karen Reed will start next week. That's the next one. But I will probably be joining Shizzy a bit for, I think he's doing the day bell.
from Nikolai Mew's legal team.
All right, we are back in the presence of the jury with the attorneys and Mr. Mew. Mr. Truffesy.
May it please the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're going to have to determine is what happened on July 30th, 2022. Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him.
Hey, Stalin.
They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Mew, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Mew acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go, and more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is the law. 1, there is...
You have wicked bad hearing. I said I have Karen Reed starting next week, but I will be probably joining Shizzy doing Daybell until then.
No duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs.
See you later, genitals.
Not the actions, but the beliefs of Mr. Mew. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Juwan Cockfield. The video perspective that the jury is required to consider it is as Nick Mew is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Mew doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Mew, calling him a raper. I'm not talking about that one. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Mew, right? I think to a person, they testified, yeah, we were really concerned about Mr. Mew. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him?
Nope.
Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again,
No.
all Nick Mew had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Juwan Cockfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Juwan Cockfield said it best of all. It's for the culture. He wanted to put it on the internet so other people can see it. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the air? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Mew's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls.
Mhm.
But he also says, the boys didn't invent that. No, they pretty much invented that.
Yeah, that was a stupid argument.
And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it. They don't say anything about Nick Mew telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you, no, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you?
Yeah.
He's with his wife.
Oh.
Thank you, Legendary, for the gifted membership. One of them you were gifted to yourself. Chrissy got one. Heretic got one. Phoenix, and that's a tough one. Got gifted one. Thank you
I
so
love
much.
it. Legendary thanked himself also.
Yeah. He's a nice guy, Legendary. You should thank him more. Yeah. You always go around out in the woods and say, hey, I'm looking for small girls.
Yeah, so how's your day going? Oh, I'm looking for small girls.
Yeah.
I really like that. I don't know why. That was funny.
A stupid argument.
He has lunch with his wife and his friends.
Brandon doesn't agree.
In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife. He's with his friends. They're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for the police. And I'm going to tell a bunch of drunk teenagers I've never met before. That's what I'm doing.
Oh my God, stop it.
Tell me that
That's
makes
crazy.
sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that. Nick said that. They find Ariel's phone in the river. So we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield is looking for a phone, and Cockfield's holding the phone. Joanne Cockfield's holding the phone. We know that Nick Mew walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb. He's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go.
She's
So,
queen of the river.
she's
I wish
moving
you would have
him.
called her a
We know
river
that.
Karen.
We know that Nick is uncomfortable, so he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she's put
She's
her
been
hands on him.
anointed. Did he just say?
We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him. Again, he tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was
Jesus, the anointed one.
someone in the group, the brave group of 6, tells Nick Mew, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children,
A beat
I'm
down.
going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it, But the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does
Judge, I can't see the exhibits. We do a rebuttal.
And step up and go over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Mew's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
Show the full video.
What is he on? Whoa! 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 Get away! Oh God! We up! We up! What are you talking about? What the hell are you talking about? What? Get away from us! What? What's going on with y'all, homie? He's on camera. Tripping. He's on 4K. Yo, the new iPhone got that good quality. What did you say?
What did you say? I hate that word.
Yeah, what the hell? Who is this? Yes, yes, yes. For the culture! For the culture! Who is that? For the culture! Who is that? Who the hell is this? Bro, it doesn't matter. He said he was looking for little girl! He said he was looking for little girl! You're looking for little girl? Yeah! That's exactly what he said. We're not us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? We're trying to have fun. He's gonna claim you. He's gonna claim you. We don't want this motherfucker. That is on camera. That is on camera. He on camera. Oh God. Oh God. He on camera. Oh God. He on camera.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Mew has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Joanne Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong.
I did that. I did a poll after state closed. 13% said guilty back then.
How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face.
Yes.
She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Mew pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother, because maybe she either took the photos or were sent the photos. No, not there either. You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay. Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Mew's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't.
Thank you, Iris, for gifting 5 memberships. One to Valhalla, Palola's mom, mom of 10, Sweet Woman, and Ian Dub.
Have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drunk teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark. Okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills.
Iris is the best, yes.
1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Mew. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people getting injured. Because it's moving like this.
What?
When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Mew's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Mew was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Mew was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Mew's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Mew. Nick Mew's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know.
He ain't a woman. He ain't a woman. You ain't a woman.
That's how fast it
Now,
goes.
Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Mew's getting punched in the face and knocked in the face, slapped. Okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Mew while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Mew while Dante Carlson comes in
effectively pushes him in the back.
Yeah.
and smacks Nick Mew in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man who had heart surgery is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what AJ Martin said in his testimony, when he was shown the picture of him making contact with Mr. Mew before Mr. Mew stabbed him, he said, he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Mew doesn't do a thing to him. Mr. Mew doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Mew has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second
I'm always
later
bad at deliberating.
that Isaac Schumann
I think
comes
4
up
to
to
6
him.
hours.
You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Mew. And why does it matter? Why does any of that matter? Because if you find the following, Nick Mew is not guilty of all the charges. Okay? If you find that Nick Mew believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs. Okay? If he believed the amount of force that he used was necessary to terminate that interference. Okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what
I'll
he
do that
had
when
to
closing
do
stops.
to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what? Today's the day I'm going to start stabbing people. I'm going to lead my group. I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment. Okay? Quentin Carlson is
Exactly,
about
and he
his
didn't
age.
walk to anyone.
And
He
Quentin
only
Carlson is
stared at
concerned
them.
enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? There's a point in that video where Nick Mew puts his hand in his head and says something like, my life is over.
My life is down to 2.
And Brandy Hart says, I don't know about that. They're self-defense. She says, I don't know what I would have done. But I can tell you I would have been scared shitless. She's been a police officer for 25 years. And that is her response. State never followed up with her on anything after that. That was her statement to the police. Or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peloquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schumann, and you have to find them for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Mew's mental purpose is to kill Isaac Schumann? Or is his mental purpose to get another person off of him? You get to decide that. Okay. Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schumann? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Mew wanted to get Isaac Schumann away from him. He didn't chase Isaac Schumann down. He didn't move toward Isaac Schumann. Isaac Schumann moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard D.A. Anderson say, but for medical intervention, some of these people would have died. Well, A.J. Martin would have. Dante Carlson had a hernia. He repaired a hernia. Sorry, the medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from that. And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill...
That's such a stupid argument. Jamie, you work in the hospital business. How many people get infected by when admitted to a hospital? Staph infection is one of the biggest killers because people go to the hospital, get surgery, and get an infection at the hospital.
Yeah.
It's such a stupid argument. I could get an infection because I poked my finger on Penilla's needle she sent with the bag.
The longer you stay in the hospital, the more apt you are to get
Yeah.
sick. So, just FYI.
Told them, why didn't he? He's, if you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time? He wants to kill him. Why doesn't he slash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Mew believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was nothing, no outside extraneous factor, they also say, might not be attempts, take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Randy Hart. He lies about the knife. He lies about the knife. What he and what Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful, and that he was being attacked. Okay? That he's never wavered on it. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong. Some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Mew's fear, how he felt, the shock. You heard people testify about that. The whiteness, the wide eyes, the ghost-looking color of his skin, that has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly in terms of the burden of proof and what the state has to do is they have to prove to you beyond a reason.
This reminds me of Brandon's rooster way too long, Corey. Thank you, Brandon. I agree. You know me, 45 minutes is the longest you can go.
Yeah, but I can
Doubt,
listen to him.
it's
He
not
doesn't bother
self-defense.
me.
And what does reasonable doubt mean?
He's 54 minutes in.
Well,
I think
the judge read it to you. You'll get to hear about it again.
I just like his Honestly, for me, him explaining all of the different charges and like saying it the way he does, that helps me out a lot. So I kind of like
Yes,
that part, you know.
I
and
like
taking
that
the
part,
time to
but
be like,
again, chip chop, 45 minutes. You don't need the last 15 minutes, in my opinion, because people lose interest after 45 minutes.
But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, and you say, I need a break, I need to figure this out, that's reasonable doubt.
You don't need
It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty.
hammer the point.
You're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick, you and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Mew home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstead.
Notice the poll is, what would you vote right now after hearing closing? Because rebuttal will just be the same reiterated.
Yeah, it's just going to be like, yeah, but he could have walked away. He could have walked away. He didn't have to go look for that phone. He wasn't allowed to go look for that phone. He wasn't supposed to be in that area. The River Karens told him to leave, and he didn't leave. I guarantee you. That's just
it was way better.
Say his entire defense is based on what Nick Mew told you during his testimony.
No, his entire defense was based on what you saw on the video.
Yes.
Jamie,
idiot.
I know you live in the Midwest, and Wisconsin is near where Lefty is, and I know Lefty has a little problem in the brain department. But do you need to be special to work for the state in Wisconsin?
I guess if
Couldn't
you have a low
couldn't your
IQ.
school bus be more than 3 rows?
I think it's shorter.
Oh.
No,
Thoughts
it's not
in
about
this
what
family,
he said.
beliefs in
It's
this
about what
family.
happened on that video.
What do we know about Nick Mew?
That he's
You know,
an
he's
old
smart,
guy.
speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person.
So he's
a
cunning.
skilled and prolific
So he woke up-
liar. We know
Thank
that
God.
because every word that came out of his mouth, practically since he started walking away from this group, was a lie. including to his best friend.
Video doesn't lie. The
took my
video
knife
doesn't lie.
while the knife is still
What
on
he
it.
did after isn't
The things he
anything
said to
to
Sheriff
do with
Knudsen,
what
where
he
he
did.
did
Nothing
not
to do
know
with
what's
it.
going on. And then everything he said to Investigator Hart, Lieutenant Hart.
Wow.
He is skillful at crafting a story that matches what he needs to say to avoid the
We saw the
consequences for
video.
his actions. We all know that. It's undisputed.
Idiot.
He told you himself. He's a liar. All right? He did not just not lie about the knife. He lied about all kinds of crazy things. Bizarre
Look at the
things.
kids.
Why would he say that these boys pulled his pants down? What a bizarre lie to make up,
He
right?
said tried to.
Why would he say that
And it's
two boys
possible.
pulled knives on him? He's got to say that because he knows what he
Why?
did wasn't justified. He thinks to himself, if I say one boy pulled a knife, it'd be good, but if it's two, that would be better. So he crafts this elaborate
Yeah.
story.
Elaborate story.
His entire defense rests on you believing what he said on the stand yesterday. His testimony was a disaster. He got caught in several lies on the stand. He changed his
Get into
answers
it.
a couple
You
of
didn't get caught
times
in them.
when he realized that what he said wasn't helpful to his defense, right?
I'm gonna yell, Jamie. I'll be right
He
back.
consistently remembered details from July 30th, 2022.
We saw
It benefits
the
his
video.
defense, but doesn't remember anything about what he did, any of the facts, any of the stories that he told Lieutenant Hart. How is that possible that he can only remember the facts, the beliefs he had that assist his defense, and nothing else? How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated
So
it
did the
over
kids.
and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was the fault of these boys.
What?
That's ridiculous. It's despicable. There's never been any explanation from the defense as to why Nick Mew ran up on these boys, why he grabbed their tubes, why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault.
Yes,
These
it
boys
is. It's
have beat
absolutely
themselves
their
up
fault.
every day since this happened. You saw the raw
They should.
emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable.
They made a choice.
Nobody's responsible for Nick Mew's choices but himself. He chose violence at every turn.
Every turn.
There's been some question about whether he's fragile. Part of him is fragile. His ego is fragile. As his attorney had said early last week, when he's questioning these boys, you were trying to
This is the first
humiliate
time he was ever
You were trying
called
to
a
insult
name?
him. You were taunting him. He was humiliated. He was
He just had
insulted.
it?
He didn't like these boys treating him like that.
So
He certainly didn't like Madison Cohen getting in his face, so to speak. And eventually, he did just snap.
No.
He pulled his knife out, getting ready for violence, pulls it out, holds it down where nobody can see it, holds it at his side, and then hits her. That started the violence. He prepared for the
So with
violence
the
before
same
he started
hand
it.
that he had it in? You idiot.
He felt humiliated, and he wasn't going to let it go. I asked him, did you ever take a step back?
No, he
Any
doesn't
time
have
she was
to.
yelling at you? No,
I gotta yell again, Jamie.
with no explanation. We're dealing with what we call false narratives in this case. Things that the defense repeats over and over and over again, hoping that you think it's fact, okay? One of these is this 13-to-1 narrative, okay? We've heard it 100 times in this trial. This is not a 13-to-1 situation. We've got the 6 teenage boys standing on the side by their tubes. He's confronted by the two girls. Everybody else is in the background. He hits Madison Cohen when he's only got two girls standing in front of him. After the fight, it's one-on-one to start. It's Dante hitting him, and then arguably two-on-one when AJ comes up and pushes him in the back. Tony breaks it up. The fight's done. He gets off. And AJ, of course, is already tore open, so he's laying in the river. But that's the end of the fight. Mr. Mew continued violence. He chose more violence after that part of the fight was done. Tony, who did exactly what his dad told him to do, came up to try to break it up. You can hear him tell Dante, his brother, get away, get back. Mr. Mew turns around and stabs him, and Tony blocks it and stabs him again. He chose violence at every turn. There's another false narrative. They circled him. They surrounded him. Baloney. You've seen the video how many times there's open water everywhere.
So the kids could just walk away.
He was attacked from all directions.
Yeah,
False
then
narrative.
why didn't, I mean, it's a, no.
He said that Owen Peliquin testified that they stuck around because they wanted to see how it played out. That's true, but what he didn't mention is that Owen also said he wanted to make sure he didn't do anything to this woman. And you know what? Those instincts were exactly right. Those instincts were right.
No, it weren't. No, they weren't. He didn't touch her.
He keeps talking about how these boys wanted to make a video. Well, they were making a video. And what does that matter? They didn't start the violence. None of those boys laid a hand on him, despite the fact that he touched both Joanne Cockfield and Landon Wire when he ran up on him in the tubes. Nobody laid a hand on him until after he'd already stabbed a number of people. Isaac Schumann tried to stop him. He got killed for his efforts.
Well,
He seems to be arguing,
sorry.
the defense seems to be arguing that Isaac somehow deserved it. I don't understand that argument. He's trying to protect people.
Well, Nick's allowed to protect himself also.
He calls Maddie Cohen the queen of the river.
And we
calls her a
appease
bully,
you.
calls her a number of other unkind things. Her testimony was, and it's clear from the video, she was trying to protect these boys. She saw that he was over there doing something, that it was freaking them out. She tried to
She
protect
didn't
them.
ask him
So
anything.
maybe if we had more people on the river trying to protect people,
Because I sped him up.
the world would be a better place.
I sped him to 1.25 because we were a little bit.
They've made over and over, they've argued that Maddie was never punched because she has no marks on her face. Nick Mew, who, as Mr. Trosty said, was lifted off of his feet by the punch from Dante, punched in the jaw and fell in the river, gets up and there's no marks on his face. We have pictures from him. We have the video. We have his interview with Lieutenant Hart later. We have the pictures that the jail nurse took 5 hours after. There's no bruising. There's no puffiness. There's no swelling.
Oh, so he didn't, it wasn't a big deal.
The fact that they're arguing that Maddie had no mark doesn't matter because he didn't either. It happens. They're trying to say that he was terrified. His face tells a different story. He has expressions of anger. He has expressions of
When?
I guess humor.
When at
He's smiling.
all?
He's smirking. Well, after he has his knife out, he clearly feels comfortable.
Oh, yeah.
There's no
He's
look of terror in
ready
his
to
face at any time.
rage.
This is so stupid.
We do
AJ
this
Martin
every
was
time.
not harmed.
Why are we surprised?
He pushed Mr. Neal.
And this is why I hate that state gets rebuttal, because he's just standing there absolutely filling their heads with carapiola right now that defense can't do anything about.
Well,
Look at
yeah,
that.
it should just
We
be
know that.
1 and 1, and
He
that's
didn't
it.
kick him. He didn't punch him. He didn't hold his head underwater. He pushed him in the back. And for that, he got a incision on his
12
body
minutes.
from his belt line all the way up. You saw the pictures. It's horrible. He used no weapon against Mr. Mew.
No, it's not Binger.
They made a big deal about Lieutenant Hart telling Mr. Mew in the interview that she would have been
Always
scared
the
too.
prosecutor.
Well, she made that response after he'd been feeding her a load of BS about all this stuff that supposedly happened. About having two
Well-
kids pulling knives on him and pulling his pants down and all the baloney that he fed her. Based on that, she said, yeah, I would have been scared too. They're arguing that he had no intent to kill Isaac. Isaac weighed 134 pounds at the time. He's 250. He rams his knife up, not down, up.
No, he
Severing
falls
2 of Isaac's
backward.
ribs
No.
right into his heart. All right. If he didn't intend to kill him, why not stab him in the belly? Right into his
Did you
heart.
see? Did you see Flux?
Yeah.
We've heard no explanation whatsoever as to why he stabbed Riley Madison. We know from the video, she's standing off in the background after Tony's trying to break it up. He just walked over and stabbed her. She wasn't
No, he
attacking him.
didn't. He stood still.
He did not
They don't
walk
explain
over.
that because there is no
and-
explanation.
No.
None. He wasn't in fear for his life from Riley Madison. She said she was 110 pounds now, might have been 115 back then. There's no fear for his life. He just was mad because she touched him.
Oh my God, no.
They've talked a little bit about extraneous factors. It's not just medical attention that can be an extraneous factor. As we know, multiple people on the river stopped to help these folks, putting compressions on. One witness said they used a sandwich bag to try to make a chest compression. There was a lot of interventions for these folks. We know with Riley Madison specifically,
Doesn't
that
matter.
Marion Davis and his
That's
brother
after.
saw it on the video, got her to shore on a tube. People went out of their way to help these folks. These are extraneous factors. But another extraneous factor is he just got unlucky. You know, if he, as Mr. Anderson had said, we've got arteries, we've got organs. Dr. Meyer said, whenever
It
you
has
have
nothing to do with the
an abdomen wound, you have to check all those things. It's kind of a miracle that more people didn't
Whether
get killed.
he's guilty
Not
is
anything
in
he
that
did.
moment in
just got
time.
lucky.
It was
That-
a miracle
no.
more people didn't get killed. Yeah. Absolute miracle. That Bigfoot that was running around out in the wood could have killed more people. Why is it a
No,
miracle
but-
more people didn't get killed? Because none of them attacked him.
Yeah.
And,
And she's right. Law and crime is all about it was self-defense. That's crazy. 50%.
yeah, then there's a chance.
Might be a chance, guys.
Flux, save my liver and build Brandon his bridge.
Missed major organs and arteries. The bottom line is he had 4 hours from the time that he was arrested to the time that he concocted this ridiculous story about the boys pulling knives on him and
There
pulling
was
his
a
pants
video,
down
so
and
it
all this
doesn't
other
matter what he
bizarre
says, to be honest with you.
Yeah.
He used his intellect, because we know he's smart, to craft
His
this story. And he was very deliberate and detailed because he wanted to come up with a story that he thought would be sufficient
very
to convince people
deliberate
that he acted in self-defense. We know he lied about all of it. So now today, he's saying, well, sure, I lied about everything I said when I talked to Lieutenant Hart about what happened, but now I'm telling the truth. So now believe me. No. You have my full confidence. I know you're going to return a just verdict of guilty and deliver justice to Isaac Schumann and everybody else who got hurt by this man. Thank you.
Yeah, it was like 52% not, or self-defense, 30% not self-defense, and then the rest.
Now,
were
members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Mew is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nikolai Mew. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds
Our
Nikolai
chat,
Mew guilty of first-degree reckless
92%
homicide
not
as
guilty,
submitted.
5% not sure,
Another form,
2% guilty.
as
So
to
our
count 1 of
guilty
the
has gone
information,
down.
Isaac Schumann, the jury
And
finds
we're
Nikolai Mew
250
guilty
here.
of
That's
second-degree
about
reckless
the same
homicide
number
as
we had,
submitted.
and 138
Lastly,
votes.
as to count 1 of the information,
So,
Isaac Schumann, the jury finds Nikolai Mew
We had
not guilty.
13% the last time I checked.
Return only 1 for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Mew commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, The jury finds Nikolai Mew guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted.
What are you doing?
Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew not guilty. Again, return only 1 for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information,
Yes,
Madison
rebuttal
Cohen,
ended.
the jury finds Nikolai Mew
yes.
guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Mew is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon your verdict and they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their
No, I'm just optimistic that they say F the instructions.
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict signed by the foreperson back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you. So we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope.
Oh, I hope it's not the 90-year-old.
The 2 alternate jurors are Darren.
Oh.
Doxed.
Whatever his name. It was a man.
You may. If you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise for the jury.
We don't know. Yeah, Darren, who? That's a good question. But the 90-year-old is a woman, so it's 50-50. Yeah, weapon are not safe or
Please be seated.
dangerous. It's a good or bad one.
Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you?
No, sir.
All right. The alternate juror forms, or the alternate, I don't know what you call this, the jurors selected for 12 the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it. You may look at it. Before we adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you, on your conduct and demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.
I know. I would too, Stephanie. Especially like this case. Like if I was sitting here, I'm like, oh, I can't wait. And they're like, you're an alternate. I'd be like, son of a.
Yeah.
I just wish for that poor one of the seniors to go down.
That's Sharosevsky did good. I don't like when they go so long. But that's a personal preference. Other people thought he was good. I hated the rebuttal. It was clearly absolutely nothing to do with what the states claimed, the defense claimed. It was just reiterating their own position.
Well, it was just they wanted to focus on the lying. See, he lied. He made the story up. He made it up. Like we didn't see a video of what happened. So, I mean, I get it. People think, oh, well, he's lying. Looks bad for him. But it's not like he was the person that was telling the story and we had no visual evidence of it going on. So.
Shamalala thought that the rebuttal was persuasive. The rebuttal was most factual. Yeah, but the rebuttal sadly had nothing to do with the self-defense part. They had everything to do with what happened after. And we have to remember, self-defense is when he does it. You can tell all the lies after. It doesn't take your right to self-defense away. He could have said, I saw Sasquatch do it. It just makes him look bad in the eyes of the jury. It doesn't change his legal position.
That's what I mean. Like the fact that he fabricated some story after the fact doesn't change what happened in the moment. What you have to decide in the moment that he was in fear of his life and used self-defense. That's what matters. That's what it is. But that's what the state does. They hang on all these little things like that just to make him look bad. And
yeah, and he was smiling and looking angry. You said he was smiling. You didn't say he looked angry. That's something you just brought now.
Yeah, he woke up. He was in a bad mood. He just couldn't wait to get.
He just had a little stabby going on. You know those days where you wake up and think,
yeah,
I'm itching from some stabbing today.
I'm ready to snap. I've never ever been violent or, assaulted anybody in my life. I haven't committed a crime. I haven't done anything. I haven't gotten a speeding ticket, but today's the day.
Yeah. I have 6 kids over here. Let's go just stabulate. Oh, 7 more comes up. Oh, just a little more.
Mm-hmm. I mean,
ooh, stab. That's how I do every day. I'm going out. I always check myself before I wreck myself, because sometimes you just have that urge.
Mm-hmm. Well,
The
and then
defense
to say
admitted he
things about
lied
the
to
kids
Brandy
too.
Hart. That story was not their defense. The defense story was that what we saw in the video. Exactly. And that's why it's stupid that they bring in everything that happened after the video. It doesn't matter. The self-defense art, self-defense has everything to do what happened when he self-defended. Whatever even if he was looking for small girls, he still have a right to self-defense if he's been attacked.
Yeah, that's all that matters is what happened in that moment. And in his mind, was he in fear of his life, and was he allowed to defend himself? That's really all that needs to be considered. Everything else can really go out the window. And the fact that there's a video and you get to see everything that happened.
Yeah. And I really hope that they will go past the lying and just watch the video again. Watch how fast it went. And he was on the floor, got up, went on the floor again, got up. 16 seconds. Yeah.
But I mean, yeah,
Exactly, John
100%.
Barry.
They focus on what they have, and that's all the state has. All the state has is all the things that happen after the fact that look bad for him. So they focus on it, and of course they do. I mean, that's all they got.
Yeah, if these 17-year-old kids didn't have a blood alcohol percent of 219, yeah, most of this didn't happen. Oh, he was standing in the back. You never saw him. Well, we saw his bracelets touch his head or his neck, and I loved how, look, he's just touching his shoulder. Yeah, that's a 1/24th of a second you're seeing there.
Mm-hmm. They're just lightly touching him, Baker.
Yeah, ineffectively pushing him down.
Mm-hmm.
The two people who were tested in group 2 had a 0.119. The only guy I think were that was because that was Dante and it was Riley, and the only one from group 1 that was tested was the decedent, and he can't metabolize alcohol. These people could metabolize alcohol because they were tested later after they had treatment, probably a blood transfusion which would dilute the alcohol percent in the blood. He had a 0.219.
Mm-hmm. Well, and I didn't like how he got all feisty about, like, I can't believe that they're saying that these kids had anything to do with this and that they did anything wrong.
Yeah, they were good kids.
They should look at their actions that day and realize that maybe.
As I wrote in, I think on Twitter, when someone was, oh, did he? I said, I hope Madison realizes she got Isaac killed.
She did.
I thought that both people we heard about had a 0.119 because Brendan brought it up, said it was weird that they had the exact same test. Yeah, 0.08 is the legal limit, but 21 years old is the legal limit. That's another little thing. Yeah, and if these parents, if they were in Michigan, could they be charged now?
Probably. Since that's a thing.
There was one that was 0.09. Yeah. Hopefully there was one of those who legally could drink. Did we ever hear what Mr. Q's level was?
Mm-mm.
Under 21, it's 0.02. So it's okay for thin girls touching a big man without his consent. Yeah, it's always okay when girls do it.
Well, even if they were big girls, they would have just emphasized they're girls. I mean, no matter how they played it, they would have played it that way.
Yeah,
but they're girls.
And was it
the girls?
If it was the 235-pound defensive end, He was just a kid.
Yeah, but he was only 17.
Yeah. Who were the designated driver? Well, Man Booth said we were going to take a cab home.
Yeah, I mean,
How many of the kids was under the drinking age? Everyone in group 1. I think the girls in group 2 were Madison was 19? Oh, sorry, I asked a question, Jamie.
no, the animals were fighting. Sorry. I don't think because like I remember the one guy said he was 19, one was 20. I think the Riley chick that came on the stand, she said she was 25 now. So I don't know what she
Yeah,
was.
she was the one who dated a 50-something-year-old man.
Oh, probably.
Well, she was. So she dated Mr. Q. She was the alcoholic, so she probably wasn't drinking. If that was my kid, I would have smacked behind and he would have told the truth. Yeah, but sadly, if you forced your kid to that, he had to admit he got his friend killed. It's better to convince yourself you had nothing to do with it because, oh my God, I am a victim.
Well, that's how he said it today, that they're
Yeah.
complete victims and that they did nothing wrong. So
In the state closed, Maddie was never up in Mew's face, and rebuttal state admitted she was up in Mew's face. Yeah, and everyone who testified said yes, she was really close to them.
Mhm.
Well, legal drinking age in Denmark is 16. No, that's when you can start. Technically, you can drink as long as your parents provided for you, but you can buy up to, I think, 20% ABV when you're 16. Mr. Q dated Starlene or whatever her damn name was. Yeah, the crack fairy.
yeah.
No, not the crack fairy. The one who left the state.
No, she was the purple-haired chick.
Yeah, she was the one that left the state.
Riley is the girl. That
Yeah, she's the crack fairy.
She's the other one.
In state closed, DA admitted the kids did something wrong, and rebuttal DA insisted the kids bore no response. Yeah, and such a stupid thing.
Well, it's funny because sometimes like people don't pick up on that, and it's like, do you hear yourselves? Did you guys like talk about your closing and rebuttal? Because you should have, because you can't have your dude up there going, well, kids will be kids, but then he's over here saying they didn't do anything wrong.
No, weed. Oh, we forgot the weed. Weed is illegal in Wisconsin. So again, it's it's just stupid. It's just all of it is so giddy stupid. And if none of them had been there, done stupid stuff like that, if they didn't feel like making a video for the culture, they none of this would happen. That's my problem. But Jamie, oh, she's gone again. Bye, Jamie. Hi, Jamie.
Hi.
Yeah, she's probably going to be on an OnlyFans soon.
Who would want
But
to
I'm
see-
thinking I'm going to ship all of you over to Shizzy. He's covering the Daybell case because you don't have to sit here and just watch me. And I'll probably jump on with him. And if anything happens, I'll shoot up a stream and we can look at it. Just so we have something interesting to do. And if you don't want to follow us over to Shizzy, follow us on Discord or on X, and we'll update you as soon as anything happens, because YouTube notification is kind of like my last girlfriend.
And
I don't know where it is. I ordered her and she never arrived. was a Smacks joke, Jamie.
Yeah, I got it.
Okay. Yeah, in Denmark, it's so funny because you can drive when you're 16, but you can't drink till you're 21. In Denmark, you can drink when you're 14. So you know what alcohol does to your body when you get to drive at 17. Well, I don't like the real thin ones. I like a little meat on the bone. Kind of like with chicken wings, even though I never had it.
The flats.
Wow, I shouldn't say that.
Or the drumsticks.
I would rather have a little meat on the drumsticks.
There you go. Good man. You know how it goes.
We can hit up J-Doll King Hefner in Memphis, but I was told Memphis is like 7 hours away from Knoxville. Sounds like a good policy to me, Andrew Baker. What now? That Andrew?
Lady, you're so happy to hear his preferences. Get in his DM, slide in.
Yeah. That's
Okay, don't do that, please. I'm sorry. I was just kidding.
no, the DMs haven't opened up. No, I'm going to send you over to Shizzy. Hopefully he will allow me to come into his chat and write too if I'm not on stream. But it's just so I can get some food and you have some trial stuff to watch. And we'll see you back later when we have questions or a verdict.
Mm-hmm.
I hope that's okay by everyone. Thank you all so much for the watches, the memberships, the monies. And I have to set it up so I can send you over because that would be real smart. I'm sending you somewhere and then I just leave. It would be a Baker thing to do, but luckily Jamie yelled at me and said, "Have you set it up?" No, I haven't. Sorry, Jamie.
You didn't even send me a link this morning, and then you yelled at me in chat.
I sent you a link, but it wasn't for StreamYard.
Yeah, you made me feel like an idiot. I had to click it again. I was like, "This is a link to your stream."
Yeah, it's because I really, really want you to watch my streams sometimes. He's covering the chat Daybill. Smecks called gone wrong, I think. Unalive, 2 or 3 people hooked up with a girl. They were arrested on a beach somewhere. I don't know.
About this,
and remember to close the poll. Thank you. Everyone is yelling at me. 29% thinks more than 6 hours. If not, if I can get my other equipment to start, tomorrow might be cinnamon roll day.
Yeah. Yum.
So yeah, it's a possibility that I'll make a baking stream tomorrow if nothing else. Adelaide, go get some sleep, and hopefully it'll be 6 hours so you can see it. He comes in and out, but I will jump over there maybe a bit later. I just need some food, and thank you all so much for hanging out with us, and hopefully you'll come back later when we have a verdict.
Yeah, and it'll
somewhere.
be what we want.
Hopefully it'll be what we want. Let's cross our fingers, toes, and noses.
Your Honor, I apologize.
What exhibit are you referring to?
I'm going to make this 100, Your Honor. 100. Because it is 100% correct.
Objection, Your Honor.
Want you to see the lawyer's face? Okay, we have to go back and they.
Widower case.
Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did.
Wait a minute, I need this story time.
Everybody has.
Everybody has.
Everyone has slept with his mother.
If I showed you.
Oof.
Oh my God.
I'm having a Jamie moment. And the way he just said it, he was just like, everyone did. Things on YouTube.
Mr. Randolph, do you?
I got to get some man. You don't know.
Called him chicken shit.
That's right. You was chicken shit.